Scott Navaroli, and Tracy Navaroli. And I thank them for their service.
Gotcha.
Traditionally,
Perfect,
in New England, town meetings serve as the legislative branch of town government. Town meeting decides whether to appropriate money to run the town and considers whether to create, revise, or remove local town statutes known as bylaws. Our town meeting in Southborough is an open town meeting, meaning that every registered voter can attend and vote on all matters before us tonight. A warrant is issued in advance of any town meeting, so voters can be forewarned of the time, place, and substance of the matters to be considered. The warrant before us tonight is a weird color. It's like peachy yellow, but hopefully you all had a chance to pick it up on your way in tonight. And on, there's a bit of introductory material, of course, and then the first article starts at the top of page 8. So when we get to Article 1, that's where you'll want to be and follow along as we go along. Unless otherwise determined by state law or by town bylaw, the conduct of town meeting is governed by the rules and practices contained in the latest edition of Town Meeting Time and Section 41 of our town code. In keeping with our longtime town practice, our proceedings tonight continue until either the scheduled end of the session, which for us tonight is 11 p.m., or that the article under consideration at that time is completed, or a quorum is called and fails, or a motion for adjournment is passed by a majority of the hall. Our past practice has been to allow non-registered voters into the hall at the start of the meeting. Typically, these people are non-resident town employees, members of the press, students from government classes, and the like. All non-registered voters can be identified by the red, white, and blue wristband and will not be allowed to speak unless approved by the hall. The non-registered voters present tonight are Heather Alker, Board of Health; Brian Valentine, Town Treasurer; Amy Berry, Assistant Town Clerk; Jeremy Berry Kahn, Intern; Paul Sabelli, Town Assessor; Trevor Dillman, Southborough Access Media; Ryan Donovan, Library Director; Kate Federoff, Town Council; Karen Galligan, DPW Superintendent; Vanessa Hale, Assistant Town Administrator; Hassan Hamid, IT Department; Laura Hayes, Advocate; Carla McAuliffe, Town Accountant; Jason Montillo, IT Director; Heather Morris, Northborough Southborough Schools; Ryan Newell, Police Chief; Terry Newman, Southborough Access Media; John Parent, Facilities; Mark Purple, Town Administrator; Corinna Quinn, Town Planner; Colleen Stansfield, Planning Department; and Luke Socorso, Southborough Police. If there are no objections, we welcome these people into the hall tonight. Do I have the consent of the hall? Please raise your cards. All opposed? All right. With that consent, we welcome these people here tonight. Laura, do you want to get your shot right now? So we have Laura from the community advocate here who would like to get a few sort of generic pictures for the community advocate. I've asked her not to take pictures of individuals in the hall tonight, but if you don't mind, go ahead, Laura, you can get up and show who you are. Just raise your cards real quick, and she's going to take a shot of everybody holding up a card and not get anybody's face. She's just going to zoom in on a bunch of red cards in the air. I appreciate your indulgence on that.
One more time, guys. Thank you, guys.
Now she may take photos of us up here, the public servants that I'll introduce here in a second, and that's okay. We're not going to do photos out there just so everybody's reassured. Thanks, Laura. Our bylaw requires me to define the bounds of the hall. Tonight, all of the seats in the Board of Selectmen chaired by Kathy Cook and your advisory committee chaired by Andrew Thap are all sitting on the front floor. With the exception of Ms. Fedorov, all of us up front are registered voters like you, but I think it's good to remind all of us that the primary and most prominent function of town meeting does not occur up front or on the stage, it occurs out there through your questions, debates, and votes. Any registered voter who has checked in tonight can go to any of the microphones, first state their name and address, and then speak to the current motion or ask a question. Any town official wishing to join the debate will likewise wait in queue at a microphone, as does any other voter. All questions should be directed through me. No one may speak until recognized by me at a microphone. This includes calls to move a question. The only exceptions of not being at a microphone are a question or a privilege or a point of order. You can rise in place and make that point if you wish. If you do make a point of order, you will still rise, be recognized, state your name and address. We will hear from everybody wishing to speak to an article, pro or con or otherwise, until I have determined that things are getting either repetitive or related. And at that point, I may suggest that we proceed to a vote. Before each vote tonight, I will remind you of the quantum of vote necessary for passage, whether it be a majority or 2/3, and then call for the vote. And if I can determine the prevailing vote from here, I will announce it. If at least 7 voters rise to question my assessment of any vote, or if I deem a vote is too close to call, I will ask the tellers to come forward to count the individual votes. Finally, before we get started, I'll touch briefly on the topic of conduct and decorum tonight. I think all of us expect that we are all ladies and gentlemen in our town in general, and certainly in a place and setting like this. So first, please silence your mobile devices if you haven't already. Remember that nobody is permitted to take or place calls within the bounds of the assembly. If you must place or take a call, you'll need to leave and do so from the lobby or outside. More importantly, on the topic of decorum, our town meeting bylaw specifically requires that speakers confine their comments to the article under consideration, as well as to refrain from mentioning by name any other person present. In any case, however, I hope it would never be necessary for me to admonish or otherwise hold anyone out of order for reasons of decorum, given that our town meeting exists to conduct our business thoughtfully and efficiently and with due regard for all. So in short, let's confine ourselves to facts and ideas and not stray into anything personal. With that, I have examined the call of the town meeting, the receipt of the officer's return of service for the posting, and the return of the mail. Nominally, the moderator must read the entire warrant, either at the beginning of the meeting or prior to the motion introducing each article, unless a motion is made to dispose or to dispense with that reading. Therefore, do I have a motion to dispense with the reading of the call of the meeting and the officer's return of service, and to waive the reading of the separate articles of the meeting? Is there a second?
Second.
All in favor? All against? All right, the motion carries. So, with that, we move to Article 1. Ms. Luttrell.
I move the article as printed in the warrant.
Okay, is there a second? Teddy, Ms. Luttrell?
Good evening, I'm Mimi Luttrell, I'm a member of your planning board and will be presenting article number 1 on behalf of the planning board. Trees in the public way, otherwise known as public shade trees, belong to all of the residents of Southborough, and there are many reasons to protect them, instead of being just one. Trees reduce flooding, erosion, they clean the air, provide cooling, improve mental health, provide habitat, and increase property values. Additionally, public shade tree protection is required by law in Massachusetts. Massachusetts was one of the earliest states to recognize the importance of public shade tree protection. Starting in 1896, an act to provide for the preservation of public shade trees was passed. 3 years later, all cities and towns in Massachusetts were required to have a tree warden. Today, the Shade Tree Law, Massachusetts General Law, Chapter 87, still has many of the same provisions as its predecessor, but goes into greater detail than the original act. The Scenic Road Law, Chapter 4015C, augments the Shade Tree Law by empowering the planning board to work with the tree warden to preserve the aesthetics on scenic roads, resulting in a more open and collaborative process. Southborough has a long history of protecting its scenic beauty and small town charm. In 1974 and 1975, several roads were designated as scenic roads. In 1978, all non-membered roads were designated as scenic roads. Then, in 2019, Southborough further bolstered its commitment to public shade tree protection with the passage of the tree bylaw, which memorialized the town's commitment to follow the shade tree law, and the town was designated a tree city. Today, we are asking you to take the next step to formalize the process to comply with the shade tree and scenic road laws. Why do we need a public shade tree bylaw? Even after 126 years, this law has not been consistently followed in Southborough. This bylaw clarifies the application of the shade tree and scenic road laws in Southborough by defining terms, setting clear standards and procedures, and establishing a more consistent process. When writing the bylaw, we didn't reinvent the wheel. We referred to Massachusetts guidelines and the bylaws already adopted by other towns and approved by the Attorney General's office. Pulling mostly from the towns of Provincetown, Cambridge, and Grafton, we also pulled from the bylaws of Greenfield, Marblehead, Barnstable, Hopkinton, Westboro, Upton, and Harvard. What does the proposed tree protection bylaw do? It clarifies the shade tree law and the scenic road law by defining terms, setting clear standards and procedures, and establishing a consistent process. Having a local bylaw makes it easier to find, easier to follow, making compliance easier. What does the proposed tree protection bylaw not do? It does not infringe on personal property rights. It only applies to public trees in the right-of-way of public roads, and therefore a public asset owned by us all. It does not impede the removal of hazardous or dead trees. Having a clear, consistent process will improve response to resident calls. It does not create additional regulation. This tree protection bylaw follows the shade tree law, compliance of which is required by all towns and cities in Massachusetts. Additionally, Southborough passed the tree bylaw in 2019, which further committed us to comply. And there is no additional cost to implement this bylaw. The provisions in the bylaw are already required by state law. What is the public right-of-way? Let's use it as an example, a standard residential road conforming to current subdivision regulations. The entire layout of the road is approximately 50 feet, of which approximately 24 feet is paved. The remaining portion is the right-of-way, which houses curbing, sidewalks, and public shade trees. The right-of-way becomes public when the road is accepted by town meeting. Not all roads in Southborough, because we date back to the 1700s, comply with current subdivision regulations. I live on an old road, and the right-of-way in front of my house is between 2 feet and 5 feet. We've had many questions about why protect the roots within the drip line of the public shade tree. Protecting the root system within the drip line is the first line of defense in maintaining the health of a tree. The support roots keep the tree upright. The destruction of them makes the tree unstable, and an unstable tree poses a danger to persons and property. starve the tree, which is why the root system is so important. This bylaw only speaks to intense activity within the drip line of a public shade tree. For example, construction or excavation, with the goal of mitigating the harm to the tree and maintaining the tree's health. Thank you very much. Please help maintain Southborough's scenic beauty and vote yes for the tree protection bylaw. I have some amendments, Mr.
Yes,
Moderator.
I understand you do. And I understand the clerk already has them.
So I have some amendments that just offer additional clarity to the bylaw and I don't change anything.
So you have it? And Jay, do you have it? Go ahead. All right, so I need you to put your amendment on the floor. Just move to amend and, yes, say the amendment.
I move to amend Article 1. Which one is this? Section D52.
Let's put that way up by Jay. There you go.
I can't see, is that section D, jurisdiction? Okay. By adding the words after public shade tree in part 5(2), that may disturb the public shade tree. So 2 would read engaging in construction or demolition activities within the drip line of a public shade tree that may disturb the public shade tree. So it matches with number 3, which says the same.
All right, is there a second to that amendment, please? Second. All right, go ahead, Mrs. Jones.
So the reason this was requested to be amended so that makes clear that disturbing the roots within the drip line, we only need a permit from the tree warden designee. If it will disturb the root system in the drip line like we discussed earlier, the support roots, the feeder roots, and damage the health of the tree.
All right, you have any other amendments? Or is this-
I do.
All right, well, we're gonna take them one at a time.
Okay.
Just to keep it clean, keep it easy to understand. Any questions or comments about this first amendment to add those words to the bylaw?
Al Hamilton, 35 Pine Hill Road. Just a quick question. A public shade tree's drip line could extend over private property, is that correct?
That's correct.
And so earlier on you said that this would not impact private property. So if the drip line is on my property, am I allowed to dig or do I need a permit?
If it will disturb the public shade tree and make this public shade tree unhealthy or unstable, you would need a permit, so as to try to mitigate that for the safety of persons and property.
So the earlier statement that this does not affect private property is not correct. Is that true?
We're all trying to protect the public shade trees that belong to all of us.
But you didn't answer my question.
Over here?
Bonnie Faniff, it's not on. Bonnie Faniff, 179 Middle Road. A follow-up question to what Mr. Hamilton just asked. The drip line, if you live in a neighborhood that's established for many, many years, like Southborough Road, which I had a home on, or you live on Cottage Street, parts of Pocketville Road, narrow streets with no backyards, your septic system is typically in the front yard, and roots are drawn to the system and to the box. I just had my septic system pulled out. I live over on over an acre lot. My system's behind my home. My old systems on Pearl Street and Southborough Road were at the front of the house, and they would be under the drip line. What is that party to do?
So the purpose is to speak with the tree warden designee, and they will try to mitigate the danger to the public shade tree. No one's going to stop you from pumping your septic system or fixing your septic system.
No, the question was, the root is in the septic system. It had to be cut out of the septic system just last week. What would happen in the future?
For one root?
They grow within inside the tank. They like the water.
So in the future, you would contact the tree warden designee, and he would decide whether that would destroy the life of the tree. Which one root wouldn't?
It was the size of a football, but I'm not talking one root. The system needs to be taken care of so the homeowner can reside in their home. You're asking for a tree warden to make a decision. In the interim, what is the party to do?
There's nothing that's going to stop somebody from repairing their septic system. The goal is to try to find a way to mitigate. If there isn't, then there isn't. But the septic system comes first.
It requires a hearing.
No hearing. No hearing. It's a permit from the tree warden designee. It's not a hearing.
Jim Caleri, 51 Central Street. For like my example, I have a flowering cherry tree in the front yard. We planted it, it's in my property. And every year I have New England Tree Master come in to properly trim the tree for its health, and now it's definitely a shade tree now as far as it's out into the edge of the road. But I do that for the health of the tree. And it's done religiously in the winter. As the arborist told me, that's the proper time to trim it. Well, I need permission from the tree warden to trim that tree, seeing my tree has grown into the area of the roadway, or the shade tree area as you talk.
Is the tree planted within the right-of-way, or is it planted on private property?
Private property.
Then it's a private tree.
Okay.
Okay. Adam Faniff, 150 Parkerville Road. It is my understanding that every single driveway in the town of Southborough is accessed via a town road. If there is a tree in my driveway that is owned by the town but extends over my driveway, and I choose to perform construction like repaving my driveway or putting in any type of landscaping on my land, would I need to go in front of the town to do so? So basically, if the tree is a town tree, but drip lines onto my property, would I need to get permission to pave my driveway based on the definition of heavy construction? Furthermore, would we need to have a meeting every time the town chooses to repave a road, which is bordered on both sides by town trees, in the drip line being the road, much like we just did on Main Street? Would we need to have a tree hearing in order to repave a road? Because that is defined as heavy construction. And I am in the construction industry, and I perform that type of work.
So is your driveway currently paved?
It is, but it requires maintenance like repaving.
So repaving wouldn't
So-
harm the roots any more than
Well-
they're already being harmed.
But we can't define where the root is growing. If the root is reaching towards the surface because we're in a drought, then now the roots are underneath my asphalt reaching for the closest water source. So if we redid that surface, we could potentially be affecting the drip line of the tree.
So if there's a question, you ask the tree warden designee, and it doesn't require a hearing.
So when would we require a hearing? If we're affecting the drip line, but we don't understand what the drip line is, when would we be required to come in and meet so that we do not incur a fine for breaking a rule of harming a tree?
So if there's a question of whether you're doing work in the drip line that will harm a public shade tree, which is a public asset, you would contact the tree warden designee and ask for him to investigate that.
him or her?
Then.
Okay, thank you. Okay, thank you.
John Gibson, 119 Northborough Road. In a couple of these previous examples, the septic system or the driveway paving, what happens if the tree warden says, yes, this activity will harm the tree and I deny your permit? What recourse does the homeowner have?
So the tree warden cannot deny a permit to fix your septic system. You know, that's Massachusetts law. The tree warden can try to mitigate the damage to the tree.
I mean, perhaps they can't deny a permit for me working on my septic system, but if I don't get permission from the tree warden to or do this, or if there are mitigations or tens of thousands of dollars to save the tree, you know, do I have to eat that cost? Can I appeal it to the select board? What happens?
So I can't imagine it would be tens of thousands of dollars. It would be to try and move the roots or work around the roots or something that would help mitigate the harm to the tree. The purpose is not to kill public shade trees that don't belong to individuals, they belong to us all.
Right, but who pays for that?
Excuse me?
If there has to be a redirection of the roots and that costs money, do I, as the homeowner doing work and maintenance on my property, do I pay for that, or is that in the town's budget?
No, you would pay for that because it's for a private purpose.
Okay, thank you.
Yes, back here.
179 Middle Road, Bonnie Fan. Point of clarification, please. On the Chapter 153 in the town code that we adopted, which you are amending this evening to add 153.5, could somebody explain to me what happened to 153-3 for the tree warden? Is that the new definition in this compared to the definition that's on the town site?
I don't have that in front of me.
It says the tree warden, the care and management of public trees shall be the responsibility of the tree warden or that official designee. The tree warden is responsible for planting, maintaining, removing trees from streets, parks, and other designated public places in accordance with Mass General Law 87-2. In the warrant article, there's no mention of 87-2.
It's under the responsibilities of the tree warden.
So that's now 153-3? So
Yeah,
you're amending 153-3 and adding 153-5, which there should be an amendment.
Well, so what you just read is the same as what's in the new bylaw, except for it goes into greater detail in the new bylaw.
But it doesn't mention Mass General Law 87-2 in the warrant.
Okay, but I don't know why that's necessary. The whole
Because it's-
bylaw is shadows Mass General Law, Chapter 87. There are 14 different sections.
I understand that, but if you're trying to clarify what we already have, you have deleted a section by not mentioning it in the new warrant under Mass General Law 87-2.
So do you want Mass General Law every section mentioned in this bylaw?
Well, apparently it shows up about 20 times that I've looked at all of them, under different sections of Mass General Law. Under 87, under 4015C.
Which is scenic roads, yes.
That's what I'm saying, either you're deleting this and adding a new job description under 153-3. Because you have a tree warden job description under the original Chapter 153 trees.
Next, right on the same side.
Katura Martin, 75 Deerfoot Road. Could you elaborate on the enforcement provision where I see that under Section M, enforcement, Section 1, it talks about violations, somebody would be subject to fines for each separate offense as provided by the tree warden designee's regulations. Are those found somewhere? Could you tell us what the actual fine schedule is for that, please?
The fines and fees will be promulgated by the select board and the planning board. So we're just speaking to the motion of the whole bylaw.
Well, it's gonna happen anyway, so you're correct that only your amendment is on the floor, but when we get back to the main motion, we're not gonna do all this again, so.
Okay.
Go ahead.
Hi, Marnie Houlihan, 26 Clifford Road. I'm speaking as planning board and as a citizen, but I just wanted to first amend Ms. Faniff's question. Ms. Luttrell, in Section C, tree warden and tree warden designee of the current warrant article, Section 4 actually does reference the duties and responsibilities of the tree warden designee under MGL's Chapter 87 in its entirety. Section 2 was a very specific designation on Chapter 87, so what this bylaw has done is to be actually able to reference the full Chapter 87. So it is in there under Section C, Part 4. And then the second comment that I just wanted to make is, as a planning board member, I fully support, planning board did vote on this, we fully support this article, and I think it's really for the interest of really just paying attention. We're in an environment these days where people aren't paying attention, trees are coming down, trees are really protective for all of us, and it just is another measure for us to be protective. There is no intention in this bylaw to be overly constrictive for homeowners, and in fact, it's really just to, if you have a question, call the tree warden and just maybe pick up the phone instead of the excavator, just to make sure it's the right thing to do, and just to have a second decision before making choices that will affect the greater good. So thank you, Mimi.
Heath Wittes, 32 Bigelow Road. Question I have is this tree warden going to be the one that's actually making these decisions and enforcing these decisions? And when those decisions are made, are those decisions just going to be basically brought before you to say thank you and put in a file? Or is the planning board going to be able to override what the tree warden has to say?
Well, the tree warden is the select board. So all decisions are made in a public meeting. And if there's activity on a scenic road, it would be a consolidated hearing with the select board and the tree warden. The tree warden designee has some day-to-day administrative responsibilities. And any decision that they make that is not agreed with can be appealed to the select board.
I would just find that a little bit dangerous, because if you have a certified arborist telling you a tree needs to come down, I would assume that you'd want to listen to what they have to say. I would be uncomfortable on voting on anything that would give anybody, whether it be the selectmen, planning board, anyone other than that individual who's trained in this and knows about it, you know, regardless of whether or not we think a tree's pretty, it might be diseased, it might need to have to come down. The minute we, as a community, override a tree warden's decision, we now assume all that liability, as far as I'm concerned. And maybe I'm crazy, and maybe I'd like to ask that question of an attorney that would be in the room representing the selectmen or the planning board. But that's something that I think people have to think about before voting for something like this. It's just not about, hey, look, we all like trees. We like how pretty our town is. But then there's the reality of the situation. Sometimes what you don't want has to happen. A tree warden would be that type of person that would be able to tell us what we need even when we don't want it. So when we're taking this vote, I think everyone really needs to think about that. I think this is something I could support if that tree warden was the person that has the ultimate decision, because that tree warden, unless he's, hopped up on drugs, is going to be making that right decision for the town. And we have to look at the liability we assume by overriding something they have to say. Because if that's the case, and we're just not going to do what a tree warden has to say, then why don't we put an article forward saying the selectmen are going to go walk and look at trees, or the planning board's going to go walk and look at trees. I don't know. I think we're jumping into this without really getting into the meat of what we're talking about.
So, everything in this bylaw is already law in chapter 87, or in chapter 40, section 15C. We're not making anything up. The tree warden in Southborough is the select board. We don't have a certified arborist on staff, although we do contract out to a certified arborist. And we just had consolidated hearings in August where we went through the reports of a certified arborist and voted to remove all the dead trees. And we walked with the certified arborist on all the resident calls and took the word of the arborist on each call that they said was the tree was diseased for one reason or another, was unsafe.
That time. So what I'm saying is,
Well,
can you assure?
It's general law, so regardless of whether, so we have this bylaw, so it gives the town clarity on how to follow what is already required of us to follow, which we haven't been very good at thus far.
Yeah, so let's get better. What I'm saying is, I'm thinking that it's probably a better idea that we look at listening to what our certified arborist, if that means that's what we have to get, we get, and that person says. Simplify this. This really seems like there's a lot of people involved in this that don't need to be. So I really think that people need to look at that. The day that that tree falls on somebody, that certified arborist said needed to come down, but the planning board or the select board said, yeah, well, because of public pressure, we're not going to do that, okay? The day that tree comes down, I just want to know, am I going to have to pay more in my taxes when we get sued, or are we just going to just pretend like these are things we don't have to talk about?
So hearings are required in Mass General Law. So this doesn't complicate anything any more than is already required in Mass General Law. So you can't just go to the tree warden designee and say, I want this tree taken down, and he'll show up with his chainsaw. Hearings are required.
I guess I would like the assurance to know that people are going to listen to those that know better than them.
Well, there's a track record of the last hearings that we've had.
Okay.
Yes, right here.
Barbara Murphy, 202 Corderville Road. I do have a concern, Bonnie's situation about the septic system. Almost everybody in this room have a septic system. I have one as well, and it's in the front yard. And it's old, and many of us are going to face things like roots growing into our septic system. I've had my septic system, not here in Southborough, but another place, back up on a Friday night when company was coming. If I have that situation and can't get the tree warden designee, or whatever that title is, to come and say, yes, I can dig up the tree and the root and get a septic system back there for the weekend, what do we do? What is the plan?
I would think that would be considered an emergency situation.
What is the plan for that?
Well, if you can't get in touch with the tree warden and say I have an emergency, you can contact the police and they will fill out a form for the tree warden.
I will hire somebody to fix my septic system that night.
Okay?
I mean, I think everybody else in this room would do that. You have one bathroom, you're not going to be without your bathroom for a whole weekend with company. I mean, that's not practical.
Public shade tree protection is the law in Massachusetts.
Right.
Every town and city is required to abide by it. And I haven't heard of any person whose septic backed up because they couldn't get the septic pumped because of a tree.
Right. But if we do that and don't have a hearing first, or notify the tree warden first, if he's on vacation, what do we do? This isn't practical to me.
It's not a hearing. A hearing, you're gonna remove the tree? To have your septic pumped, you're gonna remove the tree?
I don't know. It depends on where it is. I mean, I have trees that I know are over the septic system that I didn't plant that were there.
Are they in the public right-of-way?
Some of them may be, yes.
Okay. So to me, I think we need to use some common sense here, and it would be considered an emergency situation.
So I still don't know what happens if I do go ahead and move it, do what I do to the root, so I have a septic system, what happens after the fact? Am I fined? Am I required to replace a tree? I don't understand. That's my question.
Well, if you need to have the septic pumped, you get your septic pumped.
And cut out the root.
And cut out the root and maybe notify the tree warden in the next week or day, or just to let them know so they're aware.
And that's all?
Yes.
Okay.
Same microphone.
Debbie Demuria, 58 Flag Road, member of the planning board, but I'm speaking in my own private capacity. I think it would be useful for the hall to understand tree warden designee, and especially to the previous gentleman describing the need, in his opinion, for a certified arborist. I actually share that opinion very, very much. We have a little bit of a strange system here in Southborough that we're trying to work with, but that's sort of a little bit outside of what the planning board is trying to do. In 1991, the Southborough had a ballot initiative that went to the legislature, and it was a legislative act that several different departments were collapsed and formed into a central DPW, so cemetery, highway, trees. And in that case, the select board became the tree warden for the town. In my opinion, that's a little unwieldy moving forward, but it is the system that we have. We have a tree warden designee who works for DPW, but if you've noticed, we have had a real trouble over the last number of years where very large, mature trees that were perfectly fine and living, I'm talking 4, 5, and 6 feet diameter, were taken down. They're never going to be replaced in our lifetime, and yet dead ones are standing. And so what I think that, in my opinion, what we're trying to do is get ahead of the curve and take care of all this. Aligning with Mass General Law so that we're at least following law is the first thing. But really the second thing, and I think the gentleman pointed it out, is we really need a certified arborist. Having a board and a tree warden designee who essentially is not making strategic decisions and just carrying out the orders of a board, it really, in my opinion, isn't sustainable. It's workable, and I commend the select board and the previous planning board, before I joined, of course, for working it out and coming up with this system, because we're really trying to get Southborough's beauty to show, and that means not just removing the trees, the dead trees, but also taking care of the live trees so that they don't die. But that's maybe next steps, and so I would urge everybody to vote for this. This is just aligning with Mass General Law. Tomorrow, nothing is going to change, in my opinion. There's going to be more clarity, so there's there's no confusion. But, I'd like to see this go further, to be honest, but it doesn't go further. It simply aligns, and we all should be doing this. And had we done this years ago, we wouldn't have dead trees that are standing and live trees that are cut down. So I urge you to support this article.
Yes.
Oh, I'm sorry, I thought you were pointing to the gentleman. I've had tree hearings, and they are difficult to have when you have community members who want to protect trees, and you have members of the community that feel that they need to come down for safety reasons. So I know the process. But there's nothing in the old warrant article or this article that says, under emergency situations, a homeowner can act on their own with no fines due to corrective measures for a septic system or anything else that may put their home in danger. I'd like that as a motion.
Say that last part again, please.
I would like to have a motion on the floor that under any emergency situation to repair a septic system or to protect their home from a falling tree, that there is no penalty or fine for such action.
Okay, so if you're offering an amendment, you need to put it in writing here with clerk. And
Mr. Moderator, we're currently considering an amendment, and an amendment now would be.
I'm not accepting her pending motion.
Just pointing out that we're still considering.
Understood, and I'm having, we're trying to multitask here by having to put it in writing, and then we'll go back to point of order as well, well taken. I apologize to this gentleman, and after this article is done, the lights are coming up in here. So I apologize because I'm not seeing that well out there right now, or up here, frankly. But we'll get to that. Yes, sir.
Mark Davis, 13 Schuyler Drive. Thank you, because I'm having trouble reading what's up on the screen. I thought it was my eyesight.
Well, the funny thing is, I think the lights are down so we can see the screen better.
Okay.
We've got to find a happy medium.
Okay, thank you. I'm only speaking to the amendment. Are we commenting on the article as a whole? Because I've got comments there, but I'll withhold them until the main article is up.
If we get back to the main article and you haven't spoken to it yet,
Okay.
You will be recognized for that. So,
I'd like to ask on the drip line, is that currently in Chapter 87?
Chapter 87 doesn't specifically call out the drip line, but it calls out injury to a public shade tree.
So this language is new and above that is enumerated in Chapter 87. Am I correct?
It adds clarity to injury to a public shade tree.
Okay. My quick take on this is that I have a lot of trees on my land, and I live on a hillside. Not one of those trees is straight. And if I had a shade tree that was leaning, which every single one of the trees on my property leans, that canopy can extend 60, 80 feet into my property because the tree is leaning this way. A lot of the shade trees I see in town have roots up near the surface, and we're talking about septic systems, but we should also be talking about aeration. We should be talking about even putting in a stone wall because you're disturbing those roots which are right up close to the surface. I really think this drip line is a issue because it extends totally into private property, and that disturbs me. When I see the word a permit is discretionary. A permit means that the tree warden is going to, or the designee, pardon me, is going to make a decision. And I have issues with that because it raises a whole bunch of issues. The other question I had to ask for clarification is if there is a permit or if there is a requirement for a hearing on the drip line, is that under 87, or now are you extending that to the planning board?
There is no requirement for a hearing regarding the drip.
Okay, so Chapter 87 issues still can be determined by the tree warden at the site, holding whatever public hearing he has. Am I correct there?
The tree warden is the select board. The tree warden designee would be the issuer of the permit for construction or excavation within the drip line.
So you're saying right now I would have to go before the Board of Selectmen
For work in the drip line?
for work in the drip line.
No, you would go to the tree warden designee for a permit.
And isn't that the Board of Selectmen right now?
The designee is not the board of selectmen.
Then who is it? Who's the designee?
So, as Mr. Maria just explained, due to a legislative act in 1991, in Southborough, the select board is the tree warden. The select board has designated an employee of the Department of Public Works as the designee to do the administrative duties under Chapter 87.
Is there a current employee of the DPW acting as the designee?
Yes.
Who is that?
Chris Leroy.
All right. Let me just make just a general comment. I think part of the confusion is, and I don't mean this in a negative sense when you're talking about septic systems. I happen to agree with you that let's use common sense, but common sense is not here in this bylaw. This bylaw has words that are going to be interpreted by somebody else. And whatever has been stated here is your opinion, but it's not how this thing's going to work, and that's what I have an objection to. If I look at my street trees and I look at those drip lines, good grief, there are some leaners in there that are they're going to go up to a stone wall and into my rhododendron bushes. And suddenly I've got to now go get a permit for any of that work. And frankly, if I've got surface roots, aeration, digging, planting, putting in utilities, a sprinkler system, anything that I want to do within that, I'm suddenly up against a permit. And I have issues. I have issues with that.
All right, thank you. Yes, Mr. Dennington.
Mr. Moderator, I move the question as
Name and address, please, first.
Andrew Dennington, 10 Carolyn Terrace.
So we are, as Mr. Butler rightly points out,
Yeah.
the motion on the floor is the brief amendment.
Yes, that's would it,
Moving the question on the amendment.
to move the question on the amendment. Okay.
All right, has a second. A motion to move the question means that if you pass it and it requires a 2/3 vote, it means we stop talking about it and we vote on the amendment. The first vote is to stop talking. The next vote is the amendment itself. Is everybody clear about that? All right?
Did you get
so it's not
you got seconded? Okay.
Yes, it has been seconded. All right, all those in favor of the motion to move the question on the amendment, please raise your cards. All opposed? All right, that motion, I declare a 2/3 majority. Mr. Hagerty. All right, so now we are at the main, not the main, but the motion to amend is on the floor before you for a vote. It requires a majority vote to pass. All in favor of the amendment, please raise your cards. All opposed? All right, that motion carries. So the amendment has been passed. And so these additional words are in the bylaw. And we are back to the main motion. How, you just have one more?
No.
All right.
And two more. Three. So I move to amend section H and add the words after emergency tree removal of this bylaw to or work described in approved annual plan as described in section L.
Second. Before we proceed on that, is there any reason not to move all of your changes as one amendment? Does one depend on the other or not? You guys
No, I can move them all at once. I was
Why don't we put one amendment on the floor that contains all your changes that are remaining?
Okay.
All right, so that's the first one.
First one. The second one that's related to this one would be I move to amend section L6 after the words,
Where am I, Jake? Thank you.
after the words in compliance with the requirements of this bylaw, add, the utility shall be exempt from requirements of section H of this bylaw for work described in the approved plan. And then the last one,
No, please. All right, we'll go back to that piece of it. It doesn't match what Mr. Hegarty has. How far off is it?
Mr. Moderator,
Yes.
are we able to ask a question while that's being reviewed?
We have to put the amendment, we have to match what's in writing before we take it up. What's up with that? We're all set? Apparently we're all set. So, let's put the last change up.
the last one,
Stay there, this one.
and section J, by adding section 6, the planning board shall promulgate a tree replacement policy to carry forth the purpose and intent of this section of the bylaw.
Does that amendment, which is a three-parter, receive a second?
Second.
All right. Mr. Kalenda?
Speak to them first?
Sure.
Okay, so the first two that have to do with the utility, per chapter 87, if the utility has an approved annual maintenance plan or annual hazard tree removal plan, it's exempt from public hearings for work that is within that approved plan. So that's just adding clarity to that. And then the other one was to allow the planning board to set a policy for tree replacement.
Okay, thank you. Go ahead.
So herein lies my Dan Kalenda, 7 Blended Woods Drive.
You just did.
I welcome all to 7 Blended Woods Drive. So herein lies my challenge with this article. A number of amendments being offered by the proponent of the article the night of town meeting. So and I don't know if everyone's following every particular section that's bouncing back and forth in this. I don't know that this article is ripe for a vote tonight. I have to assume the work of this has been going on for a long time, and to propose 3 amendments and now a 4th from Ms. Faniff the night of town meeting, and asking everyone to vote on something that, again, hopefully everyone's following, maybe not, but is likely going to affect everyone in this room who has a tree on or around their property. I'm very concerned about the very fact that it's not even ready for us tonight. It wasn't ready for us before tonight because changes are being made. And the fact that this very one right here, the planning board, shall promulgate a tree replacement policy. Nobody in here knows what that policy is tonight, to carry forth the purpose and intent of this section of the bylaw. I have no idea what that policy is going to be. If anyone from the planning board has articulated that policy and can put it on as an amendment tonight, then we would know what that is going to be. We're being asked to vote on something that is being changed on the fly by the very proponent of it, believe me, Mimi, I know the work that goes into these things, so it's not easy. But that's my fear, that's my challenge, to be able to even knowingly understand and vote on something that is this important for everyone in the room when I'm not sure that it's even ready.
So thank you. Just to clarify what's on the floor right now, we had one amendment that was passed. We have a new amendment that has 3 parts. That's what's on the floor. Ms. Vanis, the sort of proposed, previewed amendment is not on the floor yet. All right? Right over here. Microphone A.
Debbie Demuria, 58 Flag Road, member of the Planning Board, but speaking as a private citizen. Just for the public to know that there was a document that was circulated, provided to the Select Board and also discussed at the Planning Board of the changes that were made as a result of several public hearings that the Planning Board held since the article was first presented in April 2020. And those articles have been, that article rather has been consistently provided in the meeting minutes by the Planning Board as they've had the different various hearings and also discussions with some of the other boards. So I think it's a little bit, disingenuous to say that, these amendments are just coming up. And they're coming up because frankly, people didn't read this tree article in response to the, when it was first presented and at the annual town meeting. There were a lot of people who felt that it was being rushed at that time, weren't prepared, and frankly, there were a lot of articles at annual town meeting. However, we've had 6 months or more to look at this, and so as time has gone by, people have now found little clarifications. The Planning Board have met with National Grid, et cetera, and some of these changes are, I think completely warranted. I would just say about policy and procedures fall outside of bylaws. And so those are rules and regulations, unless I'm mistaken, that isn't something that would be described in detail. I think it's comforting to know when you look at a bylaw that there's going to be something else, rules and regulations around it that give greater clarity for the public to go and look at. But those are set by the individual boards. That wouldn't be something that would be described. I think it's enough information to know that the Planning Board is going to set a policy for tree replacement. Thank you.
All right, thank you. Right over here, sir.
John Butler, 4 Davis Road. My question is with regard to this amendment here, the one that's shown in blue. Is Chapter 87, does Chapter 87 provide a role for the Planning Board as it currently exists? Chapter 87 of the state law provide a role for the Planning Board in promulgating a tree replacement policy, or is this a novelty of this bylaw?
So not Chapter 87, but Chapter 40, Section 15C.
And that says that
to the Planning Board, but for the tree replacement, Chapter 87 does speak to that, but it doesn't speak to the role of the Planning Board specifically.
So Chapter 87, my recollection of 87 was that it didn't specify a role for the Planning Board in tree replacement policy. Is that correct?
That's correct.
And so this section about which you're proposing to amend here, which is J, the role of the Planning Board that is created in the bylaw is new with respect to any existing law governing the town. Is that correct?
That is correct. We have no tree replacement policy in town currently.
So this would specify that we have to replace trees and the planning and a role and formalize a new role for the Planning Board in that regard. It would. So I have reservations about extending the existing 87, and that amendment is the concern that I have. But I would also say, as a general matter, it would be helpful to know the ways in which this bylaw does depart from existing law, because the statement has been made several times by you that there is no departure from existing law, but we've just found one here. Thank you.
Thank you. Yes.
John Bartolini, 4 Wyeth Circle. I'm against this bylaw, and I'll tell you why. Chapter 87 is very clear. The selectmen are in charge. Chapter 40:15, the planning board has the say on scenic roads. The selectmen are supposed to hire a tree warden. There's no mention of drip lines. There's no real punitive damage here. The other thing is, though, the bigger thing here is, in this bylaw that's being presented tonight, we have mentioned every single, the zoning board is mentioned, the Conservation Commission is mentioned, every single one is mentioned. The Recreation Board is mentioned. So to say that, oh yeah, we're going to make this simpler, we've got 5 pages here, and it goes down to 1.5 inches. Now, Chapter 87 mentions 1.5 inches, but the tree warden gets to cut that, and you get to cut that. Under this bylaw, you've got to ask somebody. It's 1.5 inches. Your index finger to your tip of your thumb. That's what we're talking about.
Over 1.5 inches or over is in Chapter 87.
Absolutely. I don't doubt you. I read it. You're right. You're correct. But the way it's administered is different. And that's what
requires a hearing on Chapter 87.
it lets the tree warden use his discretion. The problem I see here that we're having here, and I agree with a lot of things that have been said, is that these trees become emotional, and they become a battleground. And what happens is, if you have a tree at the end of your street, Strawberry Hill's got one, it's got a yellow sign on it, it's been there all summer long, but the top of it is gone. I mean, it's a no-brainer, but we're going to have a public hearing on it. It's a no-brainer. The trees and the root systems get into our roads, and then they break our roads up. We had a specialist. I was at one of the public hearings, Miss Bezanson. She grew up on Deerfoot Road. She's now a specialist. She was invited to speak to the planning board. She said there's more trees here now than there was when she was a child. I'll attest to that. There were more trees here than when I was a child. There's more people, there's more houses, but there's more trees. There's no more meadows. The reservoirs are all treed in. All the farms are gone, and there's trees, and we planted trees. In this, it also says there's a list of trees. You can't go plant your own tree. You've got to plant the tree that they want you to plant. Do we need somebody to take charge? I think so. I think the selectmen are in charge under Chapter 87. We need to hire a tree warden. We need to hire somebody on a daily basis. When I was a young man, we had Howard Truesdale. After that, we had Brian Morrow. After that, just like Deb DeMora said, we combined it into a DPW, and it kind of almost disappeared. And now we're all fighting with each other. We don't need a 5-page bylaw. We really don't. What we need is somebody say, yeah, that tree's coming down. No, it isn't. I mean, right now, I'm sorry to say, there's nothing in here about ugly. If you have an ugly tree and you want to cut it down, you can't do it. You can't do it. If you have a Japanese maple and you want to plant it, you can't do it. So I urge you to vote no on this.
So if you have an ugly tree that's on your property, you can certainly cut it down. If it's in the public right-of-way, it's a tree that's owned by us all. It's a public tree. And the issue that we're trying to solve is that Chapter 87 has not been followed here. And this bylaw adds a clear process to Chapter 87 on how it can be complied with in Southborough.
Yes.
Al Hamilton, 35 Pine Hill Road. 2 questions. One, if all of this is in Chapter 47 and it's already existing law, why do we need this bylaw? That's the first question I have, is if it's already law, we should be following the law. And just passing this law doesn't mean that we're going to be any better at following it if it merely mirrors the state law. Now, clearly, it sounds like, despite what was said, it doesn't necessarily mirror state law. The second question I have is, under state law, and the DPW, I'm sorry, the Board of Selectmen is the tree warden. Shouldn't the tree warden be the one that promulgates the tree replacement policy? Aren't we simply, tying ourselves in knots by making multiple boards responsible, for tree replacement policy? The tree warden, which is the Board of Selectmen, should be making tree replacement policy rather than, getting into these internecine fights between various boards. It's the tree warden's responsibility to formulate a tree replacement policy, and the tree warden is the Board of Selectmen.
Okay, thank you. Any other comment or question? It's clear.
I think there are, Jim Cleary, 51 Central Street, there are two options here for the planning board. My gut feeling coming to town meeting all the years I come, I think this thing is already on fire and is crashing. So you may want to consider postponing the article, and if you want to correct some of these problems you're hearing people talk about, then it'll give you the opportunity to do that. I mean, I have some reservation about, the replacement policy and all of that, having definition as to what that would be. Or my next thing, if you're not going to do that, is I was going to move the question anyway.
Well, I can't let you be the last word and then move the question.
Okay.
But if somebody else wants to do that, we can. Or you might be the last one up there anyway. I don't see anybody at the mic. Sounds like you're. That's okay, Mr. Butler. If anybody else at the mic, we can vote. So the motion on the floor is the second amendment that had three parts. Requires a majority vote.
Point of order.
Yes, who's?
Right here. Mark Davis, 13 Schuyler Drive. I'll be loud. I don't want to walk down. You've got two very different amendments. One involves the utility and one involves this policy. And I ought to represent, I am a consultant to National Grid and have been for years. My job does not involve.
All right, sir, I'm going to have to ask you to go to the mic.
Okay.
If your point is that these three changes aren't necessarily built for being approved or not together, unfortunately that's going to call for another amendment.
That's my point, because if you defeat the amendments, there are some critical utility amendments that may very well make sense. So perhaps I'm making a motion to split the motion. I don't know what the term is. We've got some objections to the last piece, but we don't seem to have any objections to the utility part of it. I just wanted to make sure that was preserved. However, I need to do that, I'll do it.
Yeah, hold on one second, please. All right, if you want to make a motion to amend this amendment and strip out either the utility piece or the policy piece, you can do that.
All right, let me just, I was not at the mic. I am a permanent consultant to National Grid, and I work for them. My role is railroad permitting, but I do get involved in forestry work. I don't have anything to do with municipal work with the street trees. But because it may be perceived that I'm talking on National Grid's behalf, which I am not, these are my personal opinions, I'd prefer if somebody else would make that motion to separate, and then there's no question.
I'm going to go, Ms. Vann, are you here on this, or are you here on your?
No, I'm here on the utility question.
You go right ahead then.
My home is 700 feet off the road. I have 3 utility poles connecting from the street pole to my home. About 4 months ago, it was brought to my attention where I have an easement for these poles, but it's my responsibility to keep the trees out of the wires. Does that include the trees at the road? Can I continue to do that?
Trees in the public way or public shade trees would fall under this bylaw.
what would be the process that I would have to go through to keep the area under those wires that I have an easement to my house for that I would have to follow?
So if the wires extend onto your property that you have an easement, this bylaw doesn't speak to that at all. It only speaks to public shade trees which are within the public right-of-way.
There are public shade trees on a utility pole that was replaced because of an accident on my property that I am now responsible to keep that area under those wires clean from the trees.
Okay, well, you keep saying it's on your property, so it's on your property.
It's a public shade tree.
Then it's not on your property.
The drip line is on my property over these wires that now I have 3 poles going to my home.
So you're going to be trimming public shade trees to keep them under the wires? I'm trying to understand.
Mass Electric has informed me that my responsibility to keep these wires clear is mine because I have an easement when the poles were put in 1972 when I built my home.
So if it's a public shade tree, it's the responsibility of the utility and the public to take care of the public shade tree with regards to the wires. An easement would be on private property.
I know, it's on my property with 3 poles. What is the process to keep a 1.5-inch diameter brush from growing along the side of the road, as Mr. Bartolini just brought up? What's the process?
So, anything over 1.5 inches that you want to remove per Mass General Law requires a hearing. If it's less than that, the town can clear the brush. As they do, they drive around with that clearing machine.
Mr. Semino?
Yes.
To make this discussion shorter, I will remove my motion and ask that this fails. There's been too many changes.
All right, and just to clarify, there was no amendment from Ms. Faniff that was officially moved. I know you previewed for it, you came up with it already, you never put it on the floor, but it's okay, I appreciate that you're saying.
Do you want me to put on?
You're not going to do it.
Do you want it on the floor?
No.
Okay. No. I think.
I'm just housekeeping
Right.
for the folks.
I mean, I'm removing it because I think it's important for the individuals in this room to understand that the authority has been under the Board of Selectmen's jurisdiction all along, and there's been too many changes here that I personally do not understand.
Thank you. Yes.
Marguerite Landry, 134 Deerfoot. I'd like to move the question on the whole warrant article.
Well, we have to dispose of the amendment first.
Okay, so then I'll move the question on the amendment.
All right.
And I'm not
We
sitting
moved
down.
the question on the amendment. I heard a second. Again, this cuts off all debate. It's not debatable. It requires a 2/3 vote, and if you pass the motion to move the question, we move immediately to a vote on the amendment. And just to be clear, the amendment on the floor has not been amended, as was suggested, to split the utility piece versus the policy piece. So it's a full amendment, all 3 parts. Motion is made to move the question. It requires a 2/3 vote. All in favor, please raise your cards. All opposed. All right, so I declare a 2/3 majority on the motion to move the question. Now we have the amendment that's on the floor, 3 parts. Requires a majority vote to pass. All in favor, please raise your cards. All opposed. All right, so that amendment fails. So now we are back to the main motion. Any further comment or question on the main motion as was briefly amended about half an hour? Yes, ma'am.
Can I move the vote on that? Which is the whole warrant article, correct?
Yes, you can. Mr. Butler was headed to the mic, but he's headed away, so we We now had a motion to move the question on Article 1.
Second.
And we have a second, same process, 2/3 vote to move the question. All in favor, please raise your cards. All opposed. All right, I declare 2/3 majority to move the question. Now on the question of Article 1, this requires a majority, it's a general bylaw, requires a majority vote. All in favor of Article 1, please raise your cards. All opposed. All right, Article 1 fails. Article 2, Ms. Houlihan.
Mr. Semino, may I just have 1 minute, please?
Where are you? Yes. Yes, and while we're just, let's take that minute to like bring the house lights up a little bit so we can all see each other. Say hi, welcome back. We're going to have to split the difference between light out there and light on the screen. And as we go through, other way, you get darker. As we go through, anybody has a question, you can't see something, obviously just let us know. Keep going, please. Or there's got to be more.
Thank you, Mr. Moderator. So I, as a planning board member and set to present warrant Article 2, noticing the time and realizing we have quite a bit on the agenda, I'm going to put one out there and hope that you guys all come and do a good favor at the next town meeting, but we'd like to indefinitely postpone to the next town meeting warrant Article 2 and bring that up when we have a little bit more time.
All right, thank you. Ms. Houlihan has moved to indefinitely postpone Article 2. Is there a second?
Second.
All right. Indefinitely postpone requires a majority vote. All those in favor, please raise your cards. All opposed. Thank you. That motion carries. Article 3, Ms. Brascio.
Hello? Okay, thank you. Thank you, Mr. Moderator. I move that the town transfer the sum of $100,000 from the overlay surplus account for the purpose of addressing public shade trees that need to be removed to ensure public safety.
Does that receive a second? All right, Ms. Bradshire, you want to speak to that?
Yes, thank you. This article will fund a backlog of tree removals that in large part have been approved through joint hearings with the Planning Board and the Select Board as the tree warden. These were over 100 trees that there were discussions on that an arborist had looked at the majority of these trees as well, and both boards were in agreement. These are not on all the roads in Southborough, obviously, but they're on select roads that we can start the backlog. The original estimate was $152,000 to remove the trees. There was close to 100 trees. And $52,000, the board voted on 10-3 to approve from the use of ARPA. So it would not hit the tax rate. Thank you.
All right, any comment or question on Article 3? All right, seeing none, this requires a majority vote. All those, I'm sorry. Yes.
Patricia Fiore, 10 Winter Street. I just have a point of clarification.
Please, name and address, speak.
I did. Patricia Fiore, 10 Winter Street. Sorry, maybe I wasn't standing close enough. I have a point, I just have a question based on what Ms. Braccio just finished with that. If this is a transfer from overlay surplus, it shouldn't affect our taxes, correct? What was it that you ended with when you were just speaking?
That it wouldn't hit the tax rate. The ARPA will not hit the tax rate either.
No, I'm talking about the 100,000.
Correct, from the overlay surplus account.
So does that surplus account need to be refunded, $100,000?
No.
So Patty, there is a thing called overlay reserve, which is done to allow for abatements of real estate taxes. So it sits there. It's an account that's got about $700,000 in it right now. The assessor looks at it every year to see what he thinks he needs for future abatements and concludes what the right balance is. So he concluded that there was more money than he needed, so he released this money into fiscal year 23 so that can be used to fund this article. So it's coming in and it's going to be spent for this. So we don't need tax levy money to pay for this.
Okay, I know. I guess I'm trying to just understand why we're getting these notices. Our taxes are going to go up 5 to 6%, yet I don't see anything in this warrant that is supporting that kind of an increase. And that was a budget that we voted on in May and funded in May. So I'm not quite sure why we need more money now. So I wanted to make sure that this was not part of the more money we obviously or are being told we need.
So we voted to take down these trees in August, and this is a mechanism to pay for them that won't require more tax money to do. So we're going to use ARPA money to pay for a piece of it, and we're going to use the overlay reserve release to pay for other piece. So this is not going to increase the taxes for fiscal year 23 at all.
Okay, still have that question about why we're needing to refund things when we voted on a budget and funding for that budget 6 months ago, but this, I get it on this one.
Okay.
Any other comment or question on Article 3? Seeing none, this requires a majority vote. All those in favor, please raise your cards. All opposed? Motion carries. Article 4, Ms. Malinowski.
I move Article 4 as printed in the warrant.
Receive a second? Second. All right, Ms. Malinowski.
Yes, so this is the fire union collective bargaining agreement that was not ready for annual town meeting, and it is effective July 1st, 2022.
Comment or question on Article 4? right, seeing none, this requires a majority vote. All those in favor, please raise your cards. All opposed? Motion carries. Article 5. Ms. Cook.
So I move Article 5 as printed in the warrant.
Receive a second. Second. Go ahead, Ms. Cook.
So I picked this one because I think it's the easiest one of the night. So long story short, we fund our insurance, property insurance deductible with a warrant article every year. So in the May town meeting, we funded this article. Unfortunately, we've had a few more claims than we expected, so we need to replenish this article. So we thought we'd go ahead and do it tonight so that we didn't run out of this by the end of the fiscal year. So we usually fund this with $10,000, so we picked $10,000 again to make sure there's enough in it to pay our deductibles. We don't run this through the insurance operating expense budget. We actually do this through a warrant article that carries over from year to year.
Comment or question about Article 5? All right, seeing none, this requires a majority vote. All those in favor, please raise your cards. All opposed? Motion carries. Article 6, Mr. Stivers.
Thank you, Mr. Moderator. I move that the town vote to allow the Select Board to grant easements to Massachusetts Electric Company doing business as National Grid for a period expiring 12/31/27. Said easements shall only be granted if they are specifically required for the installation of electric vehicle charging stations for hybrid and electric vehicles at 32 Corderville Road, the Public Safety Building, and/or other town-owned property in which there is currently parking for vehicles.
Does that receive a second?
Second.
All right, Mr. Stivers.
This is in response to a request from the police department who is transitioning to more electric vehicles going forward, and National Grid is cooperating to supply power for a charging station at the public safety complex. There is also a considerable amount of state grant money for electrical vehicle charging, and the town is interested in finding other locations for these charging stations as well. So this gives us the ability to work with Grid to get the power to where we determine these charging stations make sense. So we would hope that the town meeting supports this. Thank you.
All right, before we take comments or questions, Mr. Pfaff, you're showing up here as still an at-town meeting, but I understand that's now updated.
Yep.
Can you let the folks know where advisory is on this?
It's on the screen.
Oh, is it different on the screen? It's different than what I have in front of me. Excellent. Comment or question about Article 6? Yes.
Hi, Grant Farrington, 58 Flag Road. The motion on the screen and what Mr. Stivers read does not match what's written in the warrant. So is he making an amendment, or?
So let me explain a little bit about, it's a fair question. Parliamentary procedure is that the warrant identifies the issues. The actual motion is what we take up, and as long as it doesn't stray very far, stays within the four corners of the warrant, so people are still justifiably notified, then the motion will stand on its own. And in this case, that the change to put a little sunset clause in there at 2027, I think is fine.
Okay, so no amendment required?
No.
Thank you.
We only amend motions that are put on the floor. The warrant article itself is just a preview to what will be moved or something reasonably facsimile thereof. Hopefully that makes sense. Yes, Ms. Taylor.
179 Middle Road. Will these be made available to the employees or the individuals visiting the golf course?
I don't think that's been determined yet.
That policy will come from the Board of Selectmen?
I would expect so.
Thank you.
All right, over here, Ms. Butler.
John Butler, 4 Davis Road. I'm hoping that in approving this, if we choose to do so, that we're not approving permitting retailers of electric charging services that would be at the end of these easements, at the point of termination of the easements, to operate without fee back to the town for such a permission on town property. That is, locations for charging that are owned by a property owner typically gain royalties back from the retailer of the electricity of the charging station, and I would hope we would get that back. Is there any determination on that at this point in time, or is this only for charging town vehicles?
At this point, this is only for the public safety complex for charging town vehicles, to the best of my understanding. And I share your concern about being careful about allowing other entities to come out and make money off of this without some payback to the town.
Thank you.
I'm a single select board member, but that's something that the board, I'm sure, will take up, and folks will have a chance to talk about that.
Okay, right over here.
Yeah, Bob Flynn, 48 Wildwood Drive. My clarification question is, will these be available for public to use as well as charging stations, or just for the police and fire?
I think the intent is just police. Yeah. It's my understanding it's initially for the public safety department, and
Okay.
Again, select board will continue to consider this, and I think the idea is that we're interested in supporting development of these charging stations around town as makes sense.
Just my comment is I also support putting them in, but I think they should be open to the public.
Thank you.
All right, over here.
Marnie Houlihan, 26 Clifford. My question is, you keep referencing the public safety building, but the motion actually includes and/or other town-owned property, which is not specifically listed. I guess it would be helpful to understand what other town property is in consideration, because this is a pretty broad sweeping motion, and I think to the point that Mr. Butler just brought up, to make sure that there's assurance in place would be important before we make a widespread other town-owned property.
I'm not aware of any other near-term plan for a charging station at this point, and as again, I think that it's something that the select board will take up in public meetings, and people will have an opportunity to provide input to that. For now, it's the public safety building.
Okay, yes, over here.
Patricia Fiore, 10 Winter Street. Could you tell me how many electric vehicles the town currently owns?
One, and we're in the process of purchasing a second. Hybrid vehicles.
So that's not a charging vehicle. Is it a plug-in hybrid or gas hybrid? What?
I believe it would be a plug-in.
Well, there's a big difference. I own a hybrid, but it doesn't plug in.
I understand. But
So we have, is the town own one all-electric vehicle that needs a charging station?
Mr. Parent may be in the audience. Okay. He knows more details.
Is there any
on this.
agenda, anything on the agenda to purchase all-electric vehicles that will need a charging station?
So let's
Not on the warrant.
recognize our facilities director, Mr. Parent, to address that question.
Hi, everyone. I'm John Parent, the Director of Facilities on the town side of operations. Currently, the town owns one hybrid vehicle, and we are purchasing another one. Our goal moving forward will be...
Is that an electric hybrid? Is that a plug-in hybrid or a
No,
gas hybrid?
Our goal moving forward will be fully electric vehicles, and before we can purchase those vehicles, we need a means to charge them. So this is the primary step we need to satisfy before we can make those purchases going down the road. Ideally, our goal should be, as we move forward in time, to convert the entire fleet of police cruisers over to electric vehicles. So this is a very necessary step in order to do that. The system up at the station currently cannot handle the amount of amperage we're going to need to do that. These will be placed up near the canopy where the cruisers are parked, and we're looking to do DC direct current charges. So basically, we can charge a vehicle from nothing to full in about 20 minutes as opposed to the regular 2.5, 3 hour time. So that's basically the gist of where we're going with this.
So just to clarify, the current one hybrid car is a gas hybrid?
It's, yes, gas electric hybrid.
And the one intended to be purchased is a gas hybrid?
Yes.
Okay. When do you anticipate funding available to purchase fully electric vehicles?
If we can get this service in quickly, I'm hoping next year, maybe at the Springtown meeting.
And Ms. Fiore, we actually typically purchase 1 or 2 additional police vehicles each year. So the goal is to make that process move quickly.
Okay.
Thank you, Mr. Fair. Mr. Cleary, you're next.
Jim Cleary, 51 Central Street, and I'm also your town wire inspector. And I'm really surprised at the number of houses today in Southborough now have electric charging cars. And I think this is a move into this time and place where this town needs to really go. This is the world that we see. A lot of cities and towns are doing this, and their building departments and cars and other vehicles, including emergency vehicles, are going to electric. They have found that it is actually a better operating way to go. And I think it's important to Southborough move in this direction at this time. Yeah, they'll be putting in more than they need right now, but that moving forward, you'll be ready to go for the next generation of cruisers coming down the road. I strongly support this.
Yes.
Kelly Roney, 2 House Court. As I understand it, this is merely a town meeting delegation of authority to the select board for the purpose of granting easements. Doesn't appropriate anything. It simply provides a rapid response that the select board can make.
That's correct.
I'm in favor. Thank you.
Thank you.
All right, any other question or comment on Article 6? Yes.
Marnie Houlihan, 26 Clifford. I am going to move to amend the article to remove the and or other town-owned property. I do think it's important as town residents to understand what is the plan for electric vehicle stations, and I'd rather have that conversation at a town meeting instead of giving that blanket easement right. So I will go ahead and put that on.
All right, you come down with that in writing. Does it receive a second? Second. All right. Okay, if I understood it correctly, everything after the parentheses is being struck. You want to get ahead of it. Yeah. Let's make sure that that's an understanding. Okay, so the motion to amend has been made and seconded. The amendment is on the screen. Start the discussion on the amendment. I'm going to come back to Mr. Stivers and Cesar. Go ahead.
Thank you. Ms. Houlihan, the reason that language is in there is to provide flexibility should opportunities arise during the year to add additional charging stations at other places in town without having to go back to town meeting and delaying that process for a town meeting vote. And I think that flexibility is important for us to be able to make decent progress with this. And I think, again, it is extremely likely that that discussion will be had in public forums, and the public will have an opportunity to weigh in if you have concerns about any particular proposal for this. So I would urge people to vote against the amendment and go back to the original motion. Thank you.
My name is Joe Palmer. I live at 158 Parkerville. Disclosure, I'm a member of Capital. And anybody who watched the meeting the other night would know that Recreation wants to buy a van. They're going to buy it out of revolving funds. And their buying cycle at the moment may be in 3 to 5 months. But they were asked if they can come back with a proposal for an electric vehicle. Now, if we can't have flexibility to put in the charging stations, we cannot ask departments to change over. Verbatim, we have to come back to what? We're going to have to come back to every town meeting every 6 months to discuss every single charging station. That makes it impossible for us to go any other departments to have electrical vehicles on a reasonable buying cycle coming out of their capital or their own revolving funds. So I appreciate we operate on a level of wanting to manage and also a level of sort of distrust towards systems. But we need to have some trust in the system to allow the system to move forward at the pace that it needs to move forward when we're only doing these meetings every 6 months at best, and sometimes really only an annual meeting. We have to allow for our government to have just a little leeway to move forward. That's all I'd like to say. Thanks.
Yeah, thank you. Same microphone was next.
Kelly Roney, 2 House Court. What the 2 previous speakers said. Oppose this amendment. We should reject it. Thank you.
All right, over here.
Andrew Mills, 2 McNeil Drive. I would vote in favor of this. I think it's not unrealistic to expect that there be a plan to where they're actually going to think about putting in electric charging stations. I myself have an electric car. I'm in favor of that within the town, but I just would like to know where we're thinking of putting it in when you're going to open it up to any parking area that is owned by the town. Thank you.
All right. So we're discussing the amendment on the screen. Any further comment or question about the amendment? All right, so the amendment itself requires a majority vote. All those in favor of the amendment, which is to strike the end of the last sentence, please raise your cards if you're in favor of the amendment. All opposed? All right, so that motion fails. We're back to the main motion. Can you get rid of this, right? Okay, thank you. We're back to the main motion. Any comment or question on the restored main motion? Yes.
John Bartolini Jr., 4Y The Circle. How big of a unit? What are we talking about? I mean, it says you want to grant an easement for national. Those are wires under the ground, I assume. So then, I mean, most of the things I see plugged in, even at the Mass Pike, they're small little units. So.
Yeah, I would defer to Mr. Parent on that. I've seen a number of these charging stations, and they're the size of, sort of a medium-sized suitcase on a pole kind of thing, so
Yeah,
not huge. But Mr. Parent?
Mr. Parent, can you speak to the expected size of the charging unit?
Basically, the average unit's about the size of me. They stand tall. Again, it's the amperage, so we need to run some heavy-duty cabling underground. The one we're looking at for 32 Corderville will have to go underground through the field, and you're basically never going to know it's there, and it's because of the number of units we're putting there that we need this service. Ideally, we'd like to end up with 6 units under the canopy so the cars can just go in, plug in, and get right back out on the road.
All right, thank you.
Maybe this is a dumb question, but do you have to come to us to grant an easement to go to the?
Yeah, yes, town meeting has to grant property easements. Otherwise, we probably wouldn't be here.
Mr. Moderator, I'd like to add one little thing. There will be a transformer where the wire drops off near the canopy, just so everyone's clear. That's bigger than me. The chargers are my size. The transformer's probably going to be about, I'm going to guess, 4 to 5 feet wide, a square basically on the ground, just so we have clarity.
Yeah, concrete pad kind of thing. I'm sure we can picture it. Okay, are you coming to the mic? No? Okay. Further comment or question on Article 6? All right, now, this is an easement. It's technically an interest in property. So in order to pass this article, it requires a 2/3 majority. So that's like a grant this interest in property known as an easement. All those in favor of Article 6, please raise your cards. All opposed? All right, I declare a 2/3 majority. Article 6 passes. Article 7, Mr. Dennington.
Mr. Moderator, I move the article as printed in the warrant.
Receive a second? Second. All right, Mr. Dennington, go ahead.
Article 7 will require reasonable advance notice for any new bylaw proposed through a citizen's petition to be considered by a town meeting, and the advance notice will allow appropriate time for public notice and discussion of any such new bylaw in advance of a town meeting vote.
All right, comment or question on Article 7? Mr. Butler, I see you.
Thank you, Mr. Moderator. The explanation of this warrant is in terms of notice for bylaw changes, but citizen petitions for warrants can cover a wide range of subjects other than bylaw changes, in addition to bylaw changes. So the language as moved, I think, is correct, and I would support it. But the explanation printed, as well as the explanation provided, talks about petitions for bylaws, and that's only a small fraction of the total potential citizen petitions.
I think that's a fair point. You're right, that the Article 7 would include any citizens petition warrant article, even if it did not necessarily call for a new bylaw.
I'm gonna allow that motion, that more generic motion, notwithstanding what's written in the warrant. It's a little bit of an expansion of what's in the warrant, but it's a reasonable one in having to focus on citizens petitions. Yes, Mr. Butler.
Mr. Moderator, I have no objection to the warrant as printed. It was just I thought that the explanation, the italicized text, that's not part of the bylaw proposal, as well as the explanation, was somewhat misleading. Not intentionally so, but it was just off because, right? Thank you.
Fair enough. We're over here first. Microphone A.
Debbie Demuria, 58 Flag Road, member of the Planning Board, but speaking as a private citizen. Well, since I have 2 citizen petitions tonight, I think that I should probably give you my opinion. You can't hear? Oh, okay. Okay, you can hear me?
You gotta get right up.
Oh, man, all right. My opinion of citizens petitions is that they're written because we don't have access to our town leaders. And since I have 2 citizens petitions tonight, I want to just give you in the hall an understanding that it's not for lack of trying. I actually have 2 citizens petitions where I've tried to reach the select board, written to them, and exactly discussed what it is that I was looking to do. So I think that citizens petitions really arise because government isn't working. They are by definition outside of town government, and it raises the issue directly to the people. This is direct democracy. I think that citizens petitions should have the same cutoff as the rest of any warrant articles. And I think anybody who writes a citizens petition is very sensitive to the staff that work very hard at the townhouse. If there is a cutoff, anybody with a citizens petition would work hard to make sure that they meet the same cutoff. So what this article is doing is essentially putting a restriction on citizens petitions, but not putting any restriction on others. So it seems to me if there's a fair amount of work that has to get done, these petitions are small compared to the larger number of warrant articles that are being prepared, by the staff in the townhouse. And I don't agree that there should be a 30-day advance. I don't think that it also takes a lot of effort to go to the boards. It's up to the person who's sponsoring the petition to take their chances, frankly. If they don't take the time to go to the different boards, maybe it would fail. But that shouldn't be any burden on the staff. So this is, I think, citizens petitions should go right to the people to vote. And I don't even think that they really need to even go to the boards, but they shouldn't have a 30-day advance. So we should just use the same cutoff everybody else has for the other warrant articles. Thank you.
All right, thank you. Over here.
Al Hamilton, 35 Pine Hill Road. I served on the advisory committee for many years, and I know that there are warrant articles that were not complete until days before town meeting, proposed by various boards and the likes. So, what's good for the goose is good for the gander. If we're not going to hold the selectmen or the school committees or any other town officials to this 30-day restriction, we should not hold citizens to it. What's good for the goose is good for the gander.
Thank you. Right over here.
Patricia Fiore, 10 Winter Street. Also having had some experience with citizens petitions, I guess I need to clarify that when you're talking about submitted pursuant to chapter whatever for inclusion in any town meeting warrant, must be delivered to the Select Board's office no later than 30 calendar days prior to the date of such town meeting. But as Mr. DeMaria stated, that's not the case for the standard boards and Select Board and other departments. Is that correct? Like, I think it's 7 days for a town meeting and 14 days for a special town meeting. Is that correct? I know that's when it, but that's the state law. So I don't, is there a different shut-off time for when standard articles have to be presented, other than that 7 and 14-day period?
No, I believe you are correct that that a article that was not a citizen petition article would not be subject to the same requirement. It could be put on the, it would just be, could be put on the warrant within the time frame that the select board had to, before voting to close the warrant. Is that correct?
But there isn't a set time to close the warrant. I mean, I know by, I believe, by state law, and perhaps Mr. Hegarty can confirm this, that it has to be published in its final form 7 days before a town meeting and 14 days prior to a special town meeting. So, yes, okay, thank you. So there is no specific time that the select board closes the warrant. That's at the discretion of the select board when you feel your work is done. Is that how it's done?
Yeah, I think you're correct that after the select board votes to close the warrant, that ends any further department-sponsored warrant, articles from the select board or planning board, et cetera. I don't know, I'm getting a lot of feedback. I don't know how to stop
And
that.
one assumes.
Okay, close enough.
Turn the game down and get right up there.
Okay. Did I answer your question?
Well, so one assumes that when you are deciding upon when to close the warrant, you're taking into consideration the state mandates of the 7 and 14 days and how much time the clerk's office or what would need to put it together.
Yep, and so that there's generally been a practice, I believe, of signing the warrant at least 20 days before the date of the town meeting in question, so that it allows sufficient time to actually physically print the warrant too. So just if I can speak to this, one thing I did is I went back
It's the 30 days I object to. I agree with what's being said, is that I totally get it, that you need preparation if there's a citizen's petition, but what we get should be no different than what you get.
So, Mr. Moderator, if I can just briefly speak to this.
I can't hear you.
Mr. Moderator, can I just briefly speak to this point and respond?
I still can't hear you.
He'd like to speak to this point.
So one thing, I just looked back at the dates of this special town meeting and the annual town meeting. So for example, the citizens petition articles that you brought forward at the annual town meeting on May 4th, 2022. I look back and those were submitted on March 4th, 2022. So
March
that's well
4th for a May 4th, so that was 60 days in
yeah, so
advance.
well within it.
Yep.
That's not a problem. Here, the two citizens petitions were received on September 19, 2022. So if there was a 30-day deadline, they would need to have been submitted by September 13th, 2022. I can't tell you off the top of my head when the warrant closed, but we did have begin the discussions about having the special town meeting on October 13th. We began talking about that on August 9th. So this would have been, the citizens petition articles would have needed to come in 6 days earlier.
Can I propose a suggestion?
Okay, I just want to complete this point. I'll try to be very, sure, I'll try to be brief. So for the citizens petition articles that were received on September 19, there were 2 remaining regular select board meetings. One was on September 20th, so that did not allow sufficient time after receiving it on the 19th to talk about the 20th. So there was one remaining meeting where, and this is, I believe, after the warrant had already been printed, for the select board to consider its position on the citizens petition article. And I just think that 30 days leaves more time for the select board, the advisory committee, and any other boards that may wish to weigh in on something to have considered it, and it's September 7th is the date that we close the warrant.
So is it possible this could be amended simply to say that citizens' petitions are not accepted after the close of the warrant?
I think that's a question really for the moderator.
Because at the close of the warrant, that's when you are giving us, as the residents, fair warning about articles you want. So
okay, sorry.
we should get the same amount of time.
But here, I think the 30 days would work in favor of someone who is bringing forward a citizen petition article, because here, if we voted to close the warrant on September 7th, and you had 30 days before the meeting, that would have been September 13th. If you were bringing forward a citizen's petition article, you'd be actually better off in that circumstance. So there, it actually, the rules would work better, that citizens petition articles could get in later than town-sponsored articles. Again, the whole point is just that there should be some reasonable date by which the select board advisory committee can consider this, get public comment, solicit advice from town council as necessary, and I think 30 days is a reasonable number. And for the citizens petitioned articles at the annual town meeting this year, there was no question that they came in well within that. They came within 60 days rather than 30 days.
So you would not support an amendment that basically says we get what you get, that citizens petitions are shut off when the warrant closes?
Well, I wouldn't support it, and I think...
I mean, if you just set a policy saying the warrant closes for everybody, wouldn't that make it more simple?
All right, so I know why you're standing up, right? I think there is one element that's missing here.
All right.
Which town council has advised, which is that for a citizen's petition only, somebody correct me if I get this wrong, for a citizen's petition only, it is a special, small s, special thing. And it can't be, absent a bylaw, it can't be cut off. It can come in the day before town meeting. So the question really is, what's the reasonable number of days? Do I have that right, Jim?
I don't think you do it after printing the
Until the
warrant.
warrant is printed.
Yeah.
Until the warrant is printed.
So can I?
So this isn't a bylaw change? Oh, it is a bylaw change.
So to Ms. Fiore's point, I want to clarify my prior answer a little bit. One of the impetuses for this was our previous understanding was that citizen petition articles that come in after the close of the warrant were not timely. Then we received different guidance that, as Mr. Semino said, that if you do not have a town bylaw that sets a deadline for the submission of citizen petition articles, that they can come in as late as the date that the warrant is printed. Posted, which would allow basically like zero time to consider it. So in giving further thought to your suggestion of just having the same deadline, I think that does make sense, because that's basically what our understanding was before. So that would be the same deadline for
Makes it simple.
citizen petition articles. So thank you for your suggestion.
Well, we can still put it in. Let's go to this bottom.
John Butler, 4 Davis Road. So I was involved with this for decades of time on advisory committee, and also submitted somewhere between half a dozen and a dozen citizens petition articles during my period of high activity in the town. And I think that the proposal as written has merit, including is better for people who want to bring forward citizens petitions. And I'll explain why I think we should stick to the 30-day time. The way it was previously, and this understanding won't work given the current town council's opinion, but before the town council's opinion, the situation was that we believed that citizen petitions could come in until the date at which the warrant closed. So if, like me, you were trying to bring forward a citizen petition on occasion, you needed to find out when the warrant was going to close. And there might be a vote at some next selectmen's meeting at closing the warrant, or it might come the selectmen's meeting after that. And you're out gathering signatures. The problem is that the date of the closing of the warrant is variable, and you don't know when you have to get your citizen's petition in order to meet the deadline. You're never sure when it's going to happen. And I labored under that many times, trying to gather signatures in December for fear that the annual town meeting warrant was going to close on January 1st. This 30-day time period is reasonable and advantageous for people who want to gather citizens' petitions, because they know when they have to get the petition in, by what date. I would have far preferred it, having brought forward many citizen petitions over decades of time. Also, it's better for the boards in terms of consideration of it, because I sat on advisory committee for a long time. We should not, the problem of boards bringing forward changes to the warrant late, the last minute, which we've all seen, is not a practice we should encourage. If we have a chance to say, let's be sure it's 30 days, and it potentially advantages the petitioners as well as the consideration of a warrant article that comes before this meeting, let's take advantage of that. The problem, these boards that bring forward changes at the last minute, like we saw it to some degree in Article 1 tonight, but we've seen year after year, at times, last minute changes to the warrant, and warrants coming in late, that just hurts the whole process. So if we have a chance to fix that in part, let's fix it in part, and then hope that the rest of the process gets its act together enough to minimize the last minute changes. But I will say that the main reason for supporting this, in my view, is that a clear date helps those citizens who want to bring forward petitions by knowing exactly what date they have to work with, and not waiting for some decision on the select board's part about when the warrant is closing, because you never know when that's going to be voted by the select board. You need to know a certain date. 30 days is reasonable and constitutes good practice for the town as a whole that the whole town ought to emulate. So I urge you to support this unamended as it is. Thank you.
All right, over here.
Debbie Demurian, 58 Flag Road. I agree we need a known cutoff. I agree with Mr. Butler, but I don't agree with the 30 days. And I just want to play out a scenario for my two citizens petitions tonight. If I did not submit them within the 30 days, I could have maybe collected enough signatures to prompt a special town meeting. And so I would like some clarification on how many signatures would it take for that, because that wouldn't be advantageous to anybody to do that. So if I missed, for example, the 30-day cutoff, I submitted the petitions on September 19th, but let's say this year the 30-day cutoff was September 13th, and I come in on the 19th, and I just miss it. Debbie, you're not going to go to special town meeting, but I had 300 signatures. Would that then prompt another special town meeting? So I'd just like some clarification on that, because I think that's costly, and I don't think that's advantageous to anybody, and that's just the wrong thing to do. The right thing to do is that we all have the same cutoff. But I would like the answer to that question. Is it 200 signatures or 300 for a special town meeting? Could you answer? I mean, I came close. I came close, is what I'm saying. I had 175 signatures. I could have come in with.
You didn't have them on a call for a special town meeting.
Right.
think that those are equivalent, but I don't want to say that.
I'm just curious then. Yeah.
Mr. Moderator, I can answer that question. The answer is that you can call a special town meeting with a petition with 200 signatures that specifically calls for a special town meeting and includes at least one warrant. but just generating 500 signatures for a warrant article won't cause a special town meeting to happen unless it specifically references that you're signing this to call a special, in order to call a special town meeting.
Okay, so my fear, if I could just respond then just quickly, is my fear is that I wouldn't do that, but somebody might do that. If they have a burning issue, they don't like something that's happening, they're putting in a citizen's petition, then they could call, they could do exactly what Mr. Butler just said and get enough signatures to prompt a warrant with one warrant article, from what I understand, to prompt a special town meeting, which is costly to the town. So, although that's ridiculous, it could happen if you have that kind of a cutoff. So let's just all have the same cutoff. Thank you.
All right, thank you. Yes.
Sam Stivers, 7 Presidential Drive, member of the Select Board. I'd pushed for this last year, and I think that the 30-day cutoff is a reasonable one. As most folks may be aware, I'm probably, with Mr. Butler, in the running for submitting the most citizen petitions over the last 20 years. And I'm a big fan of citizen petitions, and I think it's an important element of democracy here. But in fact, I think the downside is if you don't have a reasonable cutoff, then there's not opportunity for the public to know what's going on. So someone could submit a citizen petition to do something that was radical or crazy or whatever, and without advance notice for the public, particularly, not to mention boards and committees, that could create some real harm to the community. So it seems to me that not only is the 30-day cutoff reasonable for advance notice, it also is more liberal than having it tied to the closing of the warrant by the Select Board, which typically, in my experience, is about 60 days or more before the town meeting date. So in essence, I think this proposal is more liberal, more flexible for citizen petition submitters, which I think is a good thing. And to Ms. DeMaria's point about special town meeting, yes, you could call a special town meeting, but if you get those signatures, the requirement is that special town meeting has to be held within 45 days, so that allows a reasonable time for communication about any petition that comes through special town meeting. So I urge you to support the proposal as presented originally and not the amendment. Thank you.
All right, I actually have the same microphone next and coming over here.
Al Hamilton, 35 Pine Hill Road. This issue of closing the warrant is a bit of a red herring because the Board of Selectmen in their regular process closes and then reopens and then recloses and then reopens and then recloses the warrant on a semi-regular basis. So I think that is a bit of a red herring. You would be very well advised for anyone sending in a citizen's petition to get that petition in early to try and garner support from the various boards and committees, because contrary to popular belief, this hall actually does listen to what people in the boards and committees have to say. But I think, you submit it late, you submit it at your own peril, but we shouldn't restrict citizens' rights to petition their government.
Kathy Cook, member of the Select Board, 11 Greystone Way, also probably more importantly a longtime member of advisory, as several of the speakers were. So I want to make a comment on Mr. Hamilton's goose and gander comment a few minutes ago. There's a difference between an article that's been proposed by the Select Board, Planning Board, someone inside government versus a citizen petition, in that normally Select Board has had, and advisory, has had a chance to consider that article for a long time. It may be changing, there may be minute changes to it, tweaks to it, but we know about it. With the citizens petitions articles, this time we didn't know about these two citizen petitions until the last minute. We only had one meeting left to be able to consider it, as did advisory, whose job is to make a recommendation to town meeting on them. So this is not born to try to cut off a citizen being able to do a petition. We just need the time to be able to duly, fully, and fairly consider those. However, I have sympathy for what Ms. Fiore just said. On advisory, it used to drive us crazy when we have to keep considering changes and changes and changes to articles. So I wish we could fix that too, so that we really had time to look at the final article and make a final vote and know that that's, so I've got sympathy with that too, but the citizens petition, we do need time to consider those articles, and we did not have the requisite time for the two that we're going to consider at the end of the meeting that are quite substantive and possibly controversial.
Hi, Dan Kalinda, 7 Glenwoods Drive. And Mr. Stivers, I could not agree with you more. I don't often say that, but I could not agree with you more. Well said. So I do think a reasonable period of time is good for the public to be able to consume the information that could be rapidly coming at them at a citizen's petition. I'm not exactly sure that the proponents of Article 12, which we're going to get to very soon, want to use that as a reason why where 30 days is unreasonable, when Town Council himself has stated that the commentary appended to that particular article was inaccurate and misleading. My point is, yes, Mr. Martin, my point is, I think it's important for the people to be able to have a sufficient amount of time to understand a citizen's petition and to really understand the genesis of it and both sides of it instead of something being dropped at the very last minute and then asking people to vote on it. So I would encourage, as Mr. Stivers well said, to defeat this motion and approve the motion as originally printed.
All right, over here.
Andrew Dennington, 10 Carolyn Terrace. I just wanted to follow up on the question that Ms. Fiore raised, where we started to discuss whether to entertain an amendment that would, instead of setting just a 30-day deadline for citizen petition articles, to instead make the deadline the date that the select board votes to close the warrant. And town council conferred with us about that and raised, one of the points that Mr. Hamilton raised, which is that in situations where the select board votes to close the warrant and then reopen the warrant and then close it again, that could lead to some ambiguity about what would be the appropriate deadline for the submission of citizen petition articles. So that's why brought down the amendment form, but then ultimately did not fill it out, because it does appear that the 30-day deadline is a more clearly understood deadline, and I do think it's reasonable. The rule would be, right now there's no clear rule, and to put in place some rule, I think benefits all participants, and 30 days is a reasonable amount of time. Thank you.
All right, thank you. Further comment or question on Article 7? All right, Article 7, this general bylaw requires a majority vote. All those in favor of Article 7, please raise your hands.
Yes.
Who made an amendment?
There is no amendment. There is none.
No amendment has been made. I'll take one if someone has one, but I'm not seeing one. A lot of people have an amendment on their mind, but no one wants to make it. My hands are tired a little bit. Someone want to do it or not? Okay. All those in favor of Article 7, please raise your cards. All opposed? Motion carries. Article 7 passes. Article 8, Mr. Challenger, can you please come forward and I'll explain what's happening here with Article 8. Article 8 is sponsored by the clerk, as well as myself as moderator. And so we have presumed, but you can disagree with me, that you would be in favor of Mr. Challen substituting as moderator for this article. He's been sworn to do that if the hall approves, or we can find somebody else. I'm going to be stepping away from the podium for this one. Mr. Hegarty will be swearing Ms. Berry, like he already has, to act as clerk and tally the vote on this article as well. Do I have any objection to Mr. Challen taking the microphone for Article 8? Well, like I said, he's been sworn to do it. And Mr. Challen, I appreciate it. Please.
evening. I think my official title is deputy moderator. Somebody may remember Eric Clapton's song, because it sort of talks about shooting the deputy down, so I hope no one takes that seriously tonight. So, Article 8 is to see if the town will vote to amend Chapter 41 of the town code entitled Town Meetings by adding a new section 41-6.1, voting procedure. So, as the moderator says, being proposed by the town clerk and the moderator, I guess.
Okay, Mr. Challenger.
Point of order?
Sorry?
Point of order. I think that motion needs to come from him.
Well, I didn't make the motion.
Okay.
I just read the article.
Okay.
Somebody probably would want to go ahead and say, I'll make that motion. I just read the article for explanatory purposes. So I guess, Ms. Flaherty?
Mr. Moderator, Jim Hegarty, 14 Maplecrest Drive, Town Clerk. I move Article 8 is printed in the warrant.
Second.
Could you provide some more information?
Sure. My primary responsibility at town meetings is to record the votes as expressed by the voters. And we've made a number of changes over the years. We've had 2 people, when we have hand counts, 2 people coming out, we actually record them on paper. That didn't used to be done. Yet we've still had instances where we've had, in the past 2 years, we've had 3 votes that have passed by 1 vote. And we have had several instances where I've had to call people up that have written the notations to ask them to explain what marks they made on the items. Were they part of the tally? Were they not? And honestly, it's a lot more difficult than you think to be counting in a busy hall. Is this person in favor or behind? Is their card up? Is it down? Are they moving around? It can get a little interesting. So I've gone to a bunch of different towns and see how towns that use electronic clickers, a device about half the size of my phone, how they work. And frankly, a lot of the ones that I saw, like the one Westboro uses, the darn thing is as complicated as my TV remote. I wanted no part of that. Yet, I found one that I think is very good. It's used by the House of Representatives in DC. It's used by 28 other towns in Massachusetts. And basically what this article would do would allow us, it articulates what method of voting we could use. Let me just say that this article isn't required by the state to allow us to vote by clicker or anything else. There's no requirement. It's 100% the discretion of the moderator. And the moderator will speak about that in a second. But in order for you in the hall to have an opportunity to weigh in on this, we brought this article forward. So the way we'd envision this using is that when you check in addition to getting your red voter card on your wristband, you'd get a little device on a lanyard. It's, like I say, it's about half the size of my phone, and it has 2 buttons on it, a yes and a no, and a little screen on the front of it. And on an article where the moderator chose to use that to record the method of voting, which might end up being, say, anything requiring a 2/3 vote, or anything where he'd have to call the tellers to go in the hall, you'd simply be asked in a window of, say, a 30-second window, to press the button to express your vote. And the device would record it in the 30-second window, and it shows on your screen, it's received it, and you have, it shows a 1 for yes and 2 for no, and if you change your mind in 30 seconds, it goes right back to it. I've gone to other towns to see this set up. Saw how Westwood uses these. They're terrific. I'm going out to Long Meadow in a couple of weeks to watch how they use them. It's just a terrific idea. Again, my number one responsibility is to ensure that I accurately record your votes. And I think this is more accurate than the way we do it right now. And the other benefit of this, frankly, is this will save us the better part of 45 minutes at every meeting. I've gone back and looked over the last so many meetings. It only say between 35 and 45 minutes. It was 38 minutes that we spent at the last meeting on 3 hand counts. And we have an average, kind of on a lower side of attendance tonight. But in a busy hall, you're talking 20, 25 minutes. And you know, some of you saw how long it took when we were in the gymnasium coming back and forth. So anyway, I think that this is it's a good idea. The plan would be that if this passes in May, we would rent these for one town meeting. The cost is $5,000 to rent them for one meeting, and you would get a chance to give them a test run. And if you liked how they worked, we would buy them, and the vendor would apply the $5,000 to the purchase price. I've spoken to most of the clerks in Massachusetts that have used the system. I think 17 or 18 of the ones that I get a hold of.
All but one of them liked it. The one that didn't, frankly, I don't know how that person turns a computer on at night, so it's not the clicker's fault. All right. And the devices are really simple. I talked to Al Hamilton about this, and Al correctly said these things are basically like a garage door opener. It sends an encrypted signal. They work perfectly fine in a room like this. If we ran into a situation where we had to use the gymnasium, there's a way to put a remote antenna and bring inside of it. I just think it makes a lot of sense. It's easy to use, and I think it'll give us a more accurate vote, and it's faster. So I'd ask you to consider voting in favor of this.
Mr. Semino.
So I'm here in support of this, of Paul Semino, 109 Carriage Hill Circle. I'm here in support of this where I originally wasn't. Jim suggested this. He gets the credit for this, by the way. He suggested it to me several months ago. As he said, one obvious benefit is we save a ton of time not hand counting close votes. At the time I said, why don't we just get better tellers? But listen, I am a disciple of town meeting. I love town meeting. I'm very close to the institution of town meeting, and anything that messes with that, I'm a little unsure about. Jim spent a lot of time doing his homework, as you just heard. The main thing that I am comfortable with is two things. One is this is, as Jim said, it's not required. And for things that are, extremely routine, where we throw the cards up and it's clear, we won't go down this road. We won't be a town that suddenly becomes electronic. But where we have in the past needed to count votes, it would be invaluable. And so, you've got to trust me a little bit to deploy it. From time to time, from article to article. But I think we can do that and still maintain the flavor and tenor of what town meeting means to us. So I ended up in favor of it, and I told Jim I would say so.
I'm so smart you know with the teller comment, having done this.
Herb Kolk, 21 City Hut Lane. I want to have somebody clarify how these communicate and verify that that has received your vote. In other words, I thought I heard that it said on the remote that it recorded your vote as either yes or no, and that was from the receiver, not the transmitter in your hand, that it actually got the communication. Can somebody answer that?
Yes, it operates in a 2.4 gigahertz frequency. It sends a signal to a receiver that we connected into a laptop. We'll be using a duplicate system as well, and we will also, for redundancy, we'll have external antennas on the side just in case somebody trips and breaks an antenna or something like that. The way the device works, the moderator would open up a window, say 30 seconds of voting. During that 30 seconds, when you press a button on your device, it would show that I pressed 1 for yes, and when it receives a signal, it shows OK on your screen to show that it has recorded the vote. At any time in that 30 seconds, you can press the button to change back to 2 and so forth, back and forth. So what we'd plan to do in the spring is bring these forward to the meeting. We'd get a chance to test run them, and we would have, we already arranged students from the National Honor Society here to help people who might need assistance who are comfortable with them. But we'd do some test votes at the start of the meeting. Everyone get a chance to use them and go from there. By the way, in terms of failure, one of the questions I'd asked was, how often do these things fail? They fail because people drop and step on them. I mean, they just don't. They're really durable. And we've worked out some security features to ensure that very reasonable that people will not be able to vote twice with them. Also, an interesting aside, these things have a, for lack of a better term, an electronic serial number, almost like the SSID on your cell phone. You can assign a phone number to your device, but it always has the same SSID inside. So when these are produced, they start at number 1 and run up to 10,000. So the other towns in Massachusetts that have bought these always start at number 1. So there are 28 towns that have the device from 1 through whatever. So I asked the vendor, I said, well, why do you have to start at 1? He said, well, why would you? I said, well, I don't want to run the risk that somebody in, I don't know, Westwood or Long Meadow could come and bring a device in here and vote on our town meeting, right? Now, there are 32 separate channels, frequencies, you can jump back and forth and change these. But nonetheless, I don't want to have a chance that somebody could grab clicker 27 from Westwood and bring it here. So what we're going to do, it makes it interesting, we're going to order 600 of these, all right? So we've had two instances where we've had like 553 and 740, give or take, in the past so many years, high votes. So what we're going to do is we're going to start, instead of numbering ours at 1, we'll pick a number, I don't know, say 6,000, right? There's nobody in the country that started at 6,000, but ours will. So that even if somebody took a device from another town and brought it out here and had the same one of the 32 channels for us, it's not going to work because our device, our program will only accept from, say, 6,000 to 6,600. That also, so that's kind of an interesting, simple security feature. It also makes us a very valuable partner to the other towns that already bought, numbers 1 to 500. If they need more machines, they have to go rent them. Well, I've already talked to other clerks. I said, we're going to start with a high number. So if need be, we'll loan them the devices. And if we have a big machine device, we can borrow theirs as well. So in a nutshell, that's how it works. I'm very comfortable we can do it. And listen, at the end of the day, I hate to put the curse on this, but I've asked, have these ever failed? And they said, no, besides somebody falling or breaking a device or something. No, they haven't. And by the way, these systems, this is used for voting at the House of Representatives, D.C. They're used all over the country. The Navy uses them a bunch of places. A whole bunch of places use them. But anyway, the point of it is, if something happened and it all went sideways, we just still have the red cards. We raise our hand and vote the old-fashioned way. So we just go back to where we are. Okay.
Thank you.
Does that answer your question, Herb?
Kelly Roney, 2 House Court. I have some follow-ups about that. When I raise my hand and I see the tellers counting, I can make eye contact with them, so I know my vote's been accepted. And there are 2 of them, there's redundancy. With an electronic system, I press a button and a light changes, but I need to know for certain that my vote got tabulated. And I think some of Mr. Hegarty's answers are germane to that, but technology is great when it works. Sometimes it's hard to tell it's failed. I made a connection tonight to try to your guest with my cell phone. Can't get anything through that channel. Too many other people must be connected. So how do I know when I press that button that the light's not local in the device? I press the button, the device changes. Or how do I know that I've had a round trip to the server that says, oh yeah, we got your vote, now the light changes? Is there a sequence of light changing where you press the button, it goes yellow, comes back to you, you get a green, and the option you selected therefore confirms reception?
A couple of things. First of all, the little device on the window of it, it will display the signal strength of the battery. It'll show that they have connectivity. And then when you press a vote, it'll show OK, that your vote has been tabulated and you've received it. You'll have a chance to test run it in the spring, and you'll have a test them all those nights as well. In addition, every one of these devices would be tested ahead of time, all 600 of them, even if we only use 200 or whatever. And then you take 20 or 30 of these, is the way I've seen it done, is literally walk around the entire hall and outside to make sure they all work. So I'm pretty confident we can do it.
Good with that answer, Doug?
I'm good with that answer. I have another question, but I think I should go to the back of the line.
Is this a follow-on or a separate?
No, it's a separate question.
Okay, I'm going to go over to my left.
Matt Probst, 31 Woodland Road. The Municipal Technology Committee took this up, and we sent Mr. Hegarty a variety of detailed security questions, how the physical security would be handled, how the electronic security would be handled, and Mr. Hegarty addressed all of them, and the Municipal Technology Committee voted unanimously in favor of this, so I would encourage you to likewise vote in favor of this. Thank you.
Still on my left.
Tracy Navaroli, One Bridge Street, Board of Registrars. I take voting very seriously, and I commend Jim on advancing us to our next level of technology. And as a teller as well, it's not always easy to know who's got their hands up, who's sitting. So I think this is a clear, definitive, line on a yay or a nay, for sure. Thank you, Jim.
Yes, Kelly Roney, 2 House Court. One of the differences between town meeting and the House of Representatives is each of those clickers in the House of Representatives will show up on a board that identifies which way the representative voted. That will not be the case in town meeting. So that, I think, is a significant difference. That means we'll have secret ballot. Is that a good thing? Is that a bad thing? I'm not sure I know the answer to that.
This does, how the data is displayed is entirely up to the moderator. The way I've seen it displayed, I mean, you actually could, let's say we had, 217 of these to, there's ways to display them, but the way that I've seen the votes as they're counted in, which I think makes the most amount of sense, would see, if we're voting, say, on Article 8, you'd see that on the screen, and at the bottom you would see the total number of votes as they're counted, not the number in favor or opposed. So at the end of the 30 seconds, if that's the window that the moderator chose, at that point, you would then see how many in favor, how many against, and you see the percentage. By the way, the last time I saw, I was down in Westwood and watched one of these, and they had a vote, the last article of the night, the only time they used them, and it was a zoning article, and it's an unusual zoning article, has to do with the MBTA. It, by statute, only requires a majority vote, not a 2/3. And they used the clickers for it, and it passed, but had it been a 2/3 requirement, it would have failed by 1 vote. So it's kind of an interesting thing to see that live.
So, Mr. Paul Semino, 109 Carriage Hill Circle. Mr. Roney just made an important point that was one of the main reasons I initially opposed this, which is that it's not even essentially a secret ballot, it is a secret ballot, right? Everybody's sitting in, I mean, your neighbor might look over and see which button you pushed, but if you're careful about it, they probably couldn't. And so my intention, as long as I'm moderator, is that it will be used sparingly. Again, especially for votes that are too close to call, as Mr. Hegarty pointed out, a few of which we've had in recent years. I mean, St. Mark's Tower was 301 to 302, whatever that was. Those numbers are not right, but you get the point. But yes, it does change a little bit of the flavor of town meeting when we use these, which is why it would be my intention to use them sparingly. But yet I think there is value.
Hey, Mr. Challen. Marty Healy, 8 Upland Road. Jim, in your surveying other towns, and maybe addressing this point, which I think is a reasonable one, does the moderator ask that both things be done? In other words, there's no reason you can't hold up your card and click. I think most of us are capable of that. And that would address the question about anonymity.
Do you really want to answer that? No,
so anyway, I'm just wondering if other towns have done it that way.
No, I haven't heard that, but there's a really wide range of how towns use these. First of all, every town that followed the path that we intend to rent these for one meeting and then apply that to purchase price, everyone that gave it a test run ended up buying them. So that's a very positive thing. Some towns use them for every article. I don't think that saves time. I think it's a lot faster for most articles just to raise your hand and move on. But it's a wide range. Some people, some towns, every town has a different personality. Somebody mentioned the secret ballots. Some towns, Hull has just gone to these clickers. And Hull had crazy, I don't understand this, but Hull would have 4 or 5 secret ballots at every election, at every town meeting. By the way, we are prepared at every town meeting to have enough things to do 5 secret ballots. Some towns, believe it or not, have voting cards and bring in the voting tabulators that we use at elections and have ballots printed up, and they hand them to voters, yes, no. And when, on some things, you fill it out and you walk to the front and you put your ballot in the box. So towns just have really different flavors as to how they operate these. But to get Mr. Healy's point, I'm not aware of anybody that raises a card and goes from there. So.
Mr. Hamilton?
Al Hamilton, 35 Pine Hill Road. I was the president of a specialized wireless company, and Jim Haggerty came and asked me about my opinions on the technology and how it worked, and I think we are truly lucky to have somebody who has done as much diligence as he has done. This is a one-time trial. If we like it, we can continue on, and if we don't like it, well, we tried. So I urge you to support this article.
Any other questions or comments? I will note that the advisory vote was 5-0. I'm sorry, select board vote was 5-0 in favor. The advisory vote was 6-0 in favor. All in favor, raise your cards. All opposed? Motion carries.
Thank you, Mr. Chairman. Article 9, Ms. Brascio.
Thank you, Mr. Moderator. I move that the article be indefinitely postponed.
Ms. Brascio, is there a second? All right, Ms. Brascio has moved that Article 9 be indefinitely postponed. If people have questions about that, we can take them, but seeing none, a majority vote on this effectively takes the article off until a future town meeting, or maybe not. All in favor of, yes.
Grant Farrington, 58 Flag Road. Just want to confirm, have the clickers been purchased, or, you know, if the article is withdrawn, then we won't be able to use the clickers at a future town meeting?
Hi, thank you for the question. So the $5,000 for the clickers was actually, the board took a position to fund that out of ARPA, so it didn't hit the tax levy. And while you're there, I'll just also share that the pavement management system, we received a compact grant for that, so that won't hit the tax rate either.
Thank you.
Yeah.
Other comment, question on Article 9, motion to indefinitely postpone. All right, seeing none, this is a majority vote. All in favor, raise your cards. All opposed. Thank you. Article 10. Ms. Malinowski.
Thank you, Mr. Moderator. I move Article 10 as printed in the warrant.
Receive a second. Second. All right, Ms. Malinowski, please.
This also will not hit the tax rate. It's to transfer $12,500 from the overlay for converting and upgrading the assessor's real estate software.
All right, question or comment over here?
Just Paul Sabelli, Town Assessor. Yeah, this is a platform that is no longer going to be supported, so we definitely need this, and hoping to have this up and running in March.
Okay, thank you. Yes, Mr. Butler.
John Butler, 4 Davis Road. Did the Technology Committee take a position on this?
They did.
Mr. Probst.
Matt Probst, 31 Woodland Road. Yes, we discussed this with town IT as well as assessor, and we voted in favor of this article. I should note that we are, of course, one of the principles we're promoting is cloud first, and we'll be working with the town IT staff to ideally deploy this in the cloud where possible.
Thank you. Any other comment or question on Article 10? Sir, are you coming to the mic?
No.
All right, this requires a majority vote. All those in favor of Article 10, please raise your cards. All opposed? All right, Article 10, motion carries. Article 10 passes. Article 11, Ms. Cook.
So just like Article 10, this is also a assessor's budget item where $14,000 is being added to allow the Board of Assessors to hire the people they need necessary to do the required appraisals that the state law requires. But to add a little bit more flavor to what we're doing here, we've tried really hard to make sure that none of the money articles tonight are going to hit the tax levy. Oh, sorry.
I'm sorry if I...
So, okay, so...
Did you put this motion on the floor?
Apparently not. Okay, so I put number 11, I put the motion as in the article.
Does receive a second? All right, my apologies. Please go ahead.
Okay, so to continue, we tried really hard to keep the impact of tonight's warrant not to affect real estate taxes, because we've ended up with a higher year-over-year tax increase to houses than what we wanted and what we expected in May. Advisory was on board with this. So that's the reason that we have funded these two articles and Article 3 with the overlay reserve. So there's very little impact tonight of the year-over-year tax increase that you're going to see when you get your bills for Q3. Mr. Sabelli, anything you want to add to?
Yes, Paul Sabelli, Principal Assessor. So basically what this is the DOR requires that all Board of Assessors conduct a cyclical reinspection program of all real estate property within the community over a 10-year period. There's been a delay in our schedule due to COVID, so this article will allow our vendor to complete an additional 400 inspections beyond what we have in this year's budget to put us back on track. And we are planning on this project is to conduct 2,600 single-family home inspections, and we started this back in, I think it was March or April. We're picking it back up next week, and we'll go until the snow flies. That's it.
Any further comment or question about Article 11? Requires a majority vote. All those in favor, please raise your cards. All opposed? Motion carries. Article 11 passes. Article 12. Mr. Gordon. So you got to put your motion on the floor, and then we'll pull up the presentation.
Mr. Moderator, I move to move the article as written, Article 12 as written in the warrant.
You receive a second? Second. All right, Mr. Gordon.
I'll start my presentation.
Yeah, go ahead.
Town declared the old burial ground as the burying place for our town. This was the 7th article on the very first 322 children, 268 women, and 219 men. The records show that of the marked graves, 29 were Revolutionary War veterans, and there are possibly 25 few other records, unmarked Revolutionary War veterans. So this was the official town cemetery until about 1840, 1842, when it was declared full, and then the rural cemetery became the town cemetery. So the intent of this article is to honor all who are buried there. Only a small percentage of which are veterans, I think 6 to 8%, and preserve the historic integrity of this historic site. So what prompted this, as most of you know, there was a hearing by the select board last year, and discussions and spirited debate, but I chose not to do anything at that time. But when I did choose to do something, it was when I heard the Supreme Court decision over Boston City Hall, and thought, well, now's probably a time that I should bring this to the town. So what happened with Boston City Hall is they have 3 flagpoles in City Hall Plaza, and it looks like they fly the flag of the United States, and actually not sure that's the flag of Massachusetts. But they allow, over time, in a lot of years, they've allowed private groups to fly their flags. For example, this is the rainbow flag that's showing at probably Pride Parade, but they had allowed numerous different various groups to fly their flag, and they had never rejected a flag until they did. So they did reject a Christian flag, and that group claimed free speech rights were violated. And this is after about 20-something years of flying, flags of anybody you asked, frankly. So that group brought a lawsuit against Boston City Hall, and City Hall won, but they appealed to the Supreme Court. So this is really where this is heading. So let's just talk about flags. Flags are speech. This is the, I think, 1754, let's see, Ben Franklin flag. I mean, this is obviously a message. I love this flag. Flags are constitutionally protected form of speech. They have meaning, and meaning changes over time. And flags can mean different things to different people. And also, it's your right to fly a flag on your own property. So what we're talking about today here is flying a private flag on public property. Often, the person that's flying the flag is sending the message. Potentially, the speech is really the speech of the person, and that's clear the way that flags are used, and also how their meanings have changed over time. But the Supreme Court decision was Shurtleff versus City of Boston, May 2022, and the decision came in August. And it was that time, by the way, that I started to contact some of our town leaders about my concerns about the flags, at Old Barrel Ground. What Shurtleff said is that without a municipal flag policy, the city is creating a public forum for speech and cannot control what is being said. It also said that the city cannot deny some flags while allowing others. And so that alarmed me. And that to me says that unless the town or any town has a policy about flags, which ones can fly on public property, then we're not talking about private, but that it becomes a forum for free speech. So either you have a policy or you allow a forum. And what's going on now across various ways. And in fact, Southborough has already done that. Last year, there was a group that wanted to fly the flag of India to celebrate Independence Day or something like that. And the town chose not to do that, but did order a proclamation, I believe. And so that's perfectly fine. But the immediate need right now, I see, is in the old fairground. Because we have some flags that are flying there, and others can simply put up flags as well. I don't believe that they've ever been given an agreement to do that, but they've also not been told to take them down. And so that opens the door to other private groups that want to start putting up their flags and using this as a public forum for free speech. So in doing some research and frankly talking to a lot of people, one of the things that became very clear is that people on both sides can agree on putting up the American flag and not having our graveyard, our oldest burial ground in town, littered with flags. And for example, I had my petition signed by a veteran who was a Navy SEAL, and he said he wasn't really bothered by the flags that were up. He said it just didn't bother him, but he said, does that mean that someone can put up a Black Lives Matter flag or a rainbow flag? And the answer to that is yes. There's nothing to stop anybody from putting a flag on any of our properties right now. And so he said, well, let me sign the petition. And he wasn't the only one. So this proposal is for flag policy of only to fly the official flag of the United States in the old burial ground. And again, just to ask the select board to create said policy. There are some very simple policies that don't have to be very involved that I've proposed or will be happy to propose, and hopefully the select board will take this up. So that's all that this is, a non-binding article, and I know we're going to get into some debate, but I hope that you can all agree we do need a policy. Today we have 6 flags. Tomorrow we could have 12 flags. Next week we could have 24 flags. And I think that we could all agree that this is not the right place to have a debate and show our individual speech. We can do that at home, but we can all agree we're Americans. We can all rally around the official flag of the United States of America, and that's what I'm proposing for the older event. Thank you.
All right, thank you. I understand we have a presentation from a different viewpoint.
So good evening, Dan Kalinda. As you all know by now, 7 Lindenwood Drive, Southborough. I am a veteran. I'm a former member of the select board. I'm joined here by Mr. Wynot, who is our Southborough's veteran of former wars commander. I am the American Legion commander for the town of Southborough. There was a lot that we just heard. We could spend all night dissecting all of that. I'm going to provide a high level of some of the misinformation that's been provided, and what I see is what this article has really been about. I've highlighted a few points in Article 11 about, in accordance with state and federal preservation guidelines, and out of respect for those buried within, all additional flags on raised flag poles shall be removed. First point is, I haven't heard anything tonight about state and federal preservation guidelines. There are none that restrict the placement of historic flags within a historic cemetery. The second point, out of respect for those buried within, how is it disrespectful to fly the flags customary to the time in which those buried within lived? Many buried there would have fought and died knowing or carrying those very flags. flags in the battle for the cause of freedom. Third point, all additional flags to be removed. Removed. That has always been exactly what this effort, originally led by one person last year, has been all about. That effort failed in a 5-0 vote by the select board. And the proponents voiced back then their intention to continue their efforts to cancel these historic flags at a future town meeting. They chose this special town meeting, I believe, which is often limited in representation. The summary. I'm not exactly in line with what the folks have here, but I'm on to the summary now.
Mr. Galena, you have a.
I'll try. All right. I'll try. Okay. The summary. So points I've highlighted. That it would be consistent with preservation guidelines for municipally owned government, burial grounds, and cemeteries. Again, the reference to a U.S. Supreme Court decision regarding free speech rights under the First Amendment. I have great respect for Ms. Moria. She has served the town well over the years. She is a pharmacist, I believe, and I bet a darn good one. She's not a lawyer. I am a lawyer. I have read the opinion of I'm glad you find that amusing, Mr. Washington.
I stick to it.
I have read the opinion from the U.S. Supreme Court, as has town council. It has nothing to do with the town of Southborough. Again, the point is, what preservation guidelines? And point number 2, I agree with town council, who opined that and I quote, the commentary appended to the article to be incorrect and in some respects misleading, end quote. The U.S. Supreme Court's decision centered around free speech rights in a public forum. The city of Boston had routinely approved, as we heard correctly, the flying of upwards of 284 different flags, but denied the flying of a Christian flag. This is completely different than the practice here in Southborough. Southborough has no practice of routinely flying hundreds of various flags and accepting applications from any private group to do so. Instead, the limited number of historic flags flown at the old burial ground has remained consistent for decades and remains rightfully under the supervision of the town and the town's graves officer. It is not a private group that manages those flags. And so that everyone knows, I'm going to briefly show you what those flags are. The first one is called the tree flag, or the Appeal to Heaven flag. The design of the flag came from General Washington's secretary. In 1776, the Massachusetts General Court established the flag of the state navy. The tree flag was one of the flags used during the American Revolution. The next one is up there is the Moultrie flag, or the Liberty flag. It was designated in 1775 by Colonel William Moultrie to prepare for war with Great Britain. It was flown during the American Revolutionary War. How about this historic flag? You let me know if it's controversial. It's the Bunker Hill flag, said to have flown at the Battle of Bunker Hill early in the American Revolution. How about the Continental flag? Was reportedly carried by colonists at the Battle of Bunker Hill. The red flag features a white cannon, the upper left-hand corner, with the New England pine tree in the center. The pine tree was a common symbol representing liberty in colonial New England. And how about the first Continental Regiment flag? The origin of this flag's design can be traced to the beginning of 1776 in the city of Boston. And finally, why I think we're all here, many are here tonight, the Gadsden flag, or the Don't Tread on Me flag. In the fall of 1775, the Continental Navy was established by General George Washington and as well as Commander-in-Chief of all Continental Forces. It is not an offensive flag, but instead a defensive one. The coiled snake is ready to strike back, only if threatened, and was meant as a clear warning to Great Britain not to trample the liberties of its subjects. Colonel Gadsden of South Carolina presented this flag to be used by the Commander-in-Chief of the American Navy. A yellow field with a rattlesnake in the middle, poised to strike with these words underneath, "Don't tread on me." Research reports indicate that the original snake design may have actually come from our own Benjamin Franklin in 1754. So in summary, for every resident who signed this petition under the impression that it was an effort to protect the old burial ground with the American flag, the fact is the historic Betsy Ross flag, a reconstructed early design for the flag of the United States, and which conforms to the Flag Act of 1777, has already been proudly flying there. It's the highest flag flown and remains at the center of the other historic flags of the time to its left and right. Commander and Wynot and I, along with so many of our fellow veterans and other members of this community, see this for exactly what it is, and always has been. An effort to remove one particular historic flag, the Gadsden Don't Tread on Me flag. While that flag, along with hundreds of others, was used by some misguided individuals at the U.S. Capitol riots on January 6, 2001, that does not negate their historical significance. Were it that easy, advocates on either side would take a flag, any symbol of the other side, and use it at a rally or demonstration of their choice, and thus suddenly change its meaning. Is that how we determine historical significance here in the United States? In Massachusetts, in Southborough? No, it is not. I ask you to resoundingly defeat this petition and send a clear message that we respect our nation's history, the historic flags of our founding, and so many veterans and those who supported them buried underneath those flags, who fought to make these original 13 colonies into what it is now, the greatest democracy on earth. Let's not cancel history. Let's preserve it for generations to come. Thank you. Mr. Wynot.
Good evening. I am Steve Wynot, 208 Clover Road. I am the Veterans of Foreign Wars Commander, also a lifetime member of the Legion, and appointed by the Select Board Veterans Graves Officer. I've been appointed since 2008 when John Wilson had been appointed as the Veterans Officer. They both got some duties, and as I said, John got the paying job, and I got the non-paying job. That non-paying job was to ensure that the graves of our veterans, no matter whether it's Rural Cemetery, Burnett Cemetery, or the old burial ground, were recognized and honored. And that is what I have done for the past 14 years. Now, the flags in question, as Dan just mentioned, the biggest one and the one that precipitated this whole thing is the Gadsden flag. I was contacted in 2019 about who did the flags at the cemetery. I responded that it was myself, and the question was about the Gadsden flag. I said, is that an issue? And the response was no, just a question. In the 30-some odd years, I've been in town for 46 years. Been involved with the veterans for 37. No one has ever questioned or had any issues with the flags that have been flying. Those flags, I can attest to, have been flying for at least 20 years. The same flags, plus or minus 1 or 2. They're all the same flags, and in that same location. In 2002, the Faniff family, Peter Faniff and his family, placed that flagpole that has the Betsy Ross flag on it. That was actually the top of the old town hall flag. And at that time, he acknowledged that the flagpoles, the 6 flagpoles that we're discussing, were already there. All I have done in the past 14 years as a Graves officer by the town, not as a private entity, as has been mentioned many times here, as a Veterans Graves officer, to honor those veterans. Now, I have, by my count, there are 50 veterans in that cemetery between the Revolutionary War and the 1812. I've heard a different number up there. I was giving a listing by someone from the Historical Society from a few years back, and I have the names of those 50. And some of those names you probably recognize. Arnthank, Horn, Fay, etc. Putting those flags up each year was I took as my responsibility to ensure that those guys that fought in that war and helped to create this town were honored. In my 24 years in the military, I learned about honor and respect. And I feel here tonight, some of the comments that have already been made, that respect for our veterans is waned and is in trouble. And that's shameful. Those 6 flags that are up there, all were here, and it's been mentioned, they had nothing to do with the Southborough veterans. I'll admit that there were probably, any of those 6 flags may not have been carried in this town. And that was not the intent when they fly. The intent is to honor the veterans that are buried up there with those 6 flags from the Revolutionary era. Simple and plain. And so I got a phone call back in March of 2021 that said that I needed to take them down. And knowing my Navy background, I'm sure there was some colorful language in that conversation. And that's what started this whole thing. From that point on, it's been an effort by a small group of people to remove all those flags. And I understand that the Gadsden flag was the igniter. But it was mentioned that it's racist and it's white supremacist. And I reject that. Yeah, there are some groups out there, some nutcases, as Dan mentioned, down in DC that threw that flag. Well, if you look, there's also flags of the United States, and there are also flags of other countries up there. So where do we end this? I ask you tonight to put all that stuff aside. This is honoring the veterans that are up there. Now, there's also mentioned that anybody can put a flag up there. And that is not true. You know, if they do it, they're doing so by trespassing on town property and putting the flag up without permission. And I noticed the other day, I was up at the cemetery on Friday evening at 3 o'clock, and the flags were in the position that I had placed them back earlier this year. Sunday morning, I went up to the All Wars Memorial to lower the American flag in honor of the National Fallen Firefighters Day. And lo and behold, the flags are shifted. They were moved. And it wasn't by me. I notice stuff like that. I have a hardcore passion for our American flag and the values that we stand for. And that allows us to be in a hall like this and debate this stuff. There should be no debate on this. This never should have got here. Again, it's one small group that has made an issue out of it. And in January of this year, let me backtrack. I take the flag, I also feel responsible, and I've taken that responsibility, to ensure that all the flags that you see along Main Street, and all the flags that are in rural cemetery, I take care of that. I make sure the flags are available, and the Theater boys put them up along Main Street every year. And in the winter, they come down, because we want to try to save them. I do the same thing with the flags at the old burial ground. I take them down before the winter snowstorm hits it. I got a phone call asking me, did I take the flags down this past year because somebody was excited. Well, when I saw a posting in a Southborough Historical Society was who's out. The flags of racism and white supremacy have been removed. It's a great day. And if they go back up, rest assured, a citizen's petition will be put together. I question as well the timing of that citizen's petition at the end of this year and just before this special town meeting. However, it's there, it's out there, we're here to vote on it. So I urge you to defeat this proposal or this motion or this article. There's a lot of other things I'd like to say, but I'll pass on that for now. Thank you very much.
All right, thank you. So, yeah. Comment or question on Article 12? Yes. No, we're gonna, you guys had one, they had one. We're gonna go to the floor, I'm sure you'll get questions. And we'll start with Mr. Weisson.
Michael Weisson, 189 Cordoville Road. So this whole issue was started by two veterans here in Southborough who disagreed with the flags that certain individuals were flying. It had nothing to do with the Southborough Historical Commission, of which I was then chair. As a matter of fact, I don't think I even noticed these flags until someone pointed them out to me. And it wasn't until the January 6th insurrection, where not just the Gadsden flag, but a number of these flags were thrown over the Capitol through windows, terrorizing our legislators by people of all stripes, including veterans. New video was just released today showing the chaos of these Capitol Hill riots. And these flags, no matter what anyone says here tonight about how they were once had historical meaning, yes, they did. But you notice in the presentation that it's purportedly flown, reportedly flown, perhaps flown. There's not historical evidence linking any veteran in that burial ground to any of these flags. Not a single line or word. The fact of the matter is, this is not a veteran cemetery. There's a huge veterans memorial down the road, which actually is flying flags in contravention of federal guidelines. There's supposed to be only one American flag flying, not multiple. But that's not my problem. My problem was that these are private individuals representing their viewpoints. And to say that these flags don't have any additional meaning, look, I'm just going to read you one real quick thing. This Appeal to Heaven flag, all you have to do is go on your phone now and look at appealtoheaven.org. This flag is their motto, and here's their mission. Appeal to Heaven exists to honor the Lord by networking elected officials who are believers in Jesus Christ, who regularly attend and display a commitment to an evangelical, gospel-centered church, and who will commit to live and govern based on biblical, constitutional, and federalist principles. Is that what we are about as a town? That's what this is. Town council has ruled, incorrectly in my opinion, that he doesn't consider this to be a public forum. However, a group that I represent that is 300 individuals has made a request to fly alternative flags. There will be other requests. This is a public forum. But what he did go on to say is that these flags are the official government statement of the town of Southborough. Frankly, I think you members of the Board of Selectmen owe us an apology for punting this to us, as opposed to taking responsible and responsive action on this when you had a petition last May signed by 300 people asking to take this down. There could have been a very simple discussion at the Historical Commission about which flags were appropriate to fly there. And there is one, the Continental Colors, which may or may not, with a greater likelihood, have been involved in this and has absolutely no historical baggage to it whatsoever. But no, these certain private individuals liked these flags, wanted these flags, and continued to fly these flags. These flags do not represent what I and many individuals in this town think is appropriate. We are all entitled to our free speech. If these individuals want to fly these flags at their home, that's fine. But we need a flag policy in this town that is encompassing, inclusive, and that welcomes people of all creeds, all genders, and all faiths without symbols that are found offensive by many. I mean, the word white supremacist should make us all run away. And yet, here is this flag and all these other emblems. It's a very simple proposition. Mr. Murier, I thank you so much for doing this. Take down these flags, prohibit any other flags from flying there, and fly the American flag, because that's the one thing that actually unites us all. Thank you.
All right, thank you. Over here, Mr. Butler.
John Butler, 4 Davis Road. There's another side to this that I'd like to bring out here. I mean, while this is a good democratic debate to have, and both sides have points to be made, there is a proper democratic forum for this decision, and it happens under our law to be the Board of Selectmen. The problem I have with this proposal here is that it's non-binding. By law, it can only be non-binding, and we could have an infinite supply of these kinds of things coming before this body when they have these questions. This particular question has its proper forum before the Board of Selectmen, or the Select Board, I'm sorry, which, if you don't like their decision, the proper democratic action is to run or get someone to run who represents your point of view. This body has all of the preceding warrants that we've had to vote on tonight were warrants that can only be acted upon legally by this body. Our authority was required for them. In this action, we have no authority whatsoever. And although it's permissible to bring it forward, as is anything can be brought forward by citizens, I hate to encourage our spending time on a non-definitive, non-decisive vote of something which is a matter of public debate, but has its proper, perfectly democratic space for decision-making in this town. So I don't want to encourage an endless supply of these kinds of debates being brought forward to town meeting without being able to be resolved here. We have enough things to do here that can be resolved here that are difficult questions that we need to grapple with without every disappointed citizen, with every citizen who's disappointed with any possible decision of the Board of Selectmen, bringing them forward for reconsideration in a non-binding way here. So I would urge voting against this, not because of one side or the other that I favor. I think it's a very good debate, but it's misplaced to be here, and we have a lot of important things to do, and making a recommendation to the Board of Selectmen, which they're not bound by, is not one of those important things we have to do, and I don't want to encourage questions like this to come here. Thank you.
Okay, thank you. Right over here.
Kelly Roney, 2 House Court. Mr. Butler made an interesting point. But first of all, I'd like to thank Mr. Wynot for the work he does in putting flags on the graves of the veterans who deserve that honor, very much so. On the other hand, I don't think that he should have exclusive speech rights in the old burial ground. That seems non-neutral. The town has published some legal opinion that they obtained. The last line of the legal opinion is, the town is free to adopt a policy that limits flags flown in the cemetery to the American flag. What the opinion doesn't say is the town is free to adopt other policies as well. The one before us, the advisory article before us, is to adopt a policy only the U.S. flag. And I think Ms. DeMuria's notation that this is the flag that unites us is apt. Over time, symbols change. Symbols change in their meaning. People try to change them sometimes. We know some flags in America are verboten not by the First Amendment. You can fly them on your property, but you'd certainly never permit them to be put on public property. and certainly not as government speech. Furthermore, this opinion says that the flags on the old burial ground are government speech, but I would challenge that because I don't know of any single time the board, which is the competent authority, has ever decided that that's the speech they want to represent. So I would say, let's get a policy. Opening the conversation is valuable. Getting a sense of what the people of Southborough want spoken in their old burial ground seems important to me. Furthermore, despite the claim of fact that the cemetery itself is not a traditional public forum, I've been there on Memorial Day when speeches were made by politicians. It's a public forum. And the town's assertion that this is town speech also makes it a public forum. So let's get something in place that represents widely the diversity of opinion in town and that is pluralistic as our society is. Something that doesn't delegate to a single person the right to speak for the town. Thank you.
Thank you. Right over here.
Heath Wittes, 32 Bigelow Road. I just kind of wanted to give a little food for thought without going too deep into breaking this all down. As humans, I'm not a veteran. I support the veterans. But as humans, we live and then we die. Veterans live, fight. Many of them die fighting for us. There's a big difference there. Even if you're just looking at the veteran that fought with the risk of dying and then died like the rest of us. That component there where they either died or risked their lives for us, I guess what I could say is, let's put all this aside and say, why don't we give it to them?
Thank you. Back to this side, please.
Alex Deans Row, 17 Harris Drive. I don't have too much to say other than that I urge that we support this motion and that it passes. I strongly feel as though I'm sorry, I'm going to yield the floor to.
Okay.
I need to think this through some more.
If you come back, I'll recognize you. Let's go over here.
Hi, Colleen Hoppy, 218 Cordell Road. I'm just wondering, does nobody care about our history at all? Why are we trying to get rid of it? The old cemetery, the last time someone was buried there was in the mid-1850s or so. So why are we trying to remove a flag from the people of that era that represented that? If none of the people that are buried in there, they would be rolling around in the graves with people talking about, oh, we want to put a rainbow or a gay pride flag up or a Black Lives Matter flag up. I support every gender, I support every color, but I also support our history. And why are we trying to remove something that has been there and represents our history? If people go and misrepresent the flag at a riot, you can't fix stupid. You can't control what other people do. I'm like disgusted that my kids and my grandkids are growing up and their history's gone. They have no respect for people because we're just changing everything like this. It's, in my opinion, disgusting. That's it.
If somebody has a question for you, absolutely. Well, I haven't heard that, but
Dan Denicenzo of 158 Southville Road. The first point I'd like to make tonight is to call into doubt the amount of support we can gather from the more than 300 signatures on the citizens' petition. I, for one, and I know of at least one other individual here tonight, signed that petition. However, both of us are adamantly opposed to this article to the extent that we have chosen to come here tonight to show our opposition to it. I will only blame the rush I was getting rid of my trash and recyclables at the transfer station on a busy Saturday morning when I signed it, for not doing my due diligence and looking into what I was placing my name on. As it was, this self-imposed haste, and additionally, a certain lack of clarity in the individual I was speaking with and describing the petition itself, led me to think that this was a worthy thing to sign, and I regret that now. I think it misleading to use those signatures as an overall sign of support for the cause.
So I'm going to stop you there. It's one thing if you were confused or you didn't do your due diligence, but I'm going to stop. I'm going to draw the line at suggesting somebody was misleading you purposely.
Fair enough.
Okay.
Secondly, apart from the historicity and appropriateness of these flags flying at the old burial ground, which I think Mr. Calenda has adequately articulated, I'd like to instead express a disagreement with a formal letter that was submitted to the board that was arguing in support of Article 12 that seemed to paint with a broad brush those in our town who appreciate the display of flags like the Gadsden flag and the other historical flags in public places. In this letter's view, these types of flags have become associated with January 6, white supremacist groups, and others who believe the government should only be controlled by white Christians. These were words used in the letter. Speaking as someone who not infrequently displays the Gadsden flag at my own home, I emphatically refute that these views are utterly inaccurate. For me, the Gadsden flag represents not a political movement, it's not a political statement, but a sign that points to the relationship we as individuals have to the greatest society in which we find ourselves. It is a reminder to me, as I can assure you it is to most of us in opposition to Article 12, that there is a certain part of each of us as individuals that should be untouched, unviolated, not tread upon by the collective whole. We believe that we are intellectual and moral agents who have a right to what we think and how we conduct our business, insofar as it does no harm to others. If our town has moved beyond this type of thinking, and instead only to seek to value the responsibilities the individual has towards the collective, and not the flip side of this as the rights the collective owes to us as individuals, then this can only be seen as a backward movement that puts us more in line with much of the antiquated thinking of the world, in which many of those individuals who are buried in this burial ground lived when there were legitimate tyrannies with which they were concerned. Whether it be a government, popular opinion, or to borrow the words of John Stuart Mill in the 19th century, the tyranny of the majority, we as individuals have a unique liberty that ought to be respected by our fellow residents with whom we are neighbors. This may have been a revolutionary idea when the Revolutionary War was fought, but today, 200 to 300 years later, it is alarming that the display of these types of flags that signify an individual's liberty are considered rebellious and fringe and should not be allowed to fly. I asked for all of you to oppose this article. And one other comment for Mr. Moria, I'll ask a question. You mentioned that flags mean different things to different people. What would you say if someone thought that the United States flag that you say in your policy that we should fly here meant something negative towards them? You say we can all gather support behind that flag, but what makes you say that if flags say different things to different people?
Go ahead.
There are people that don't like the American flag, and it is their right to burn it, trample it, step on it, etc. And it's ours. And you're always going to have people who want to express their speech, and that is a protected form of that makes the American flag quite different. But to me, it's the unifying factor. Like when I look across this room and I see all these faces, I think we're all Americans. It should be the one flag that we can all agree on, even though we may not agree on some of these others. And it could be any flag. I think of the advisory who supported 4-2, by the way. I said, well, if you put a Starbucks flag up, someone might say, that's great, I love Starbucks. And someone might say, they don't pay their employees enough, that's bad, right? But I look at it and say, what is a Starbucks flag doing there? This is not, in my opinion, to really pay tribute to the people that are there. By the way, mostly families from the late 1800s. To pay tribute to those people, let's just get these flags out there. Let's not have this speech in that public forum. I don't think that's showing respect, but I think that all of us can respect the United States of America flag. So there are people, unfortunately, that don't, and there's nothing we can do but to say that we recognize that veterans fought for that free speech. That's the irony of this situation, right? But we honor that. But on the same vein, we have to be inclusive and consider that the people that are buried there, only 6% are veterans. There may be actually more veterans in other locations than our burial grounds. So it's really not a tribute to the veterans. What we should be doing is saying, we are all Americans. In this day where we're tribal, let's all agree that we're Americans and not make this about the people that are buried there. Because we would have to put up Quaker flags and all other kinds of flags if that's what we're really trying to do. So let's just all remember the people.
Thank you. Over here, please.
Yes, Eric Hall, 257 Parkerville Road. Before I give my opinion, I want to bring up a couple of stories. One's very recent, one's from about 3 years ago. A Norwegian family in Michigan, if anyone's heard this story, opened up a bed and breakfast, put 2 flags out front, an American flag and a Norwegian flag. And they were forced by locals, even though it's on private property, to take down the Norwegian flag because people mistook it for the Confederate battle flag because it was red and had stripes. Completely different looking flag if you look at them. But it was something they were forced to do based out of emotion and a little bit of ignorance. More recently, I don't know who saw the stuff about the Worcester vote last night, planning board. UMass medical students put together a proposal to rename Plantation Street because plantation has negative connotations. But in the context here, plantation was what a settlement was. You had Plymouth Plantation, you had Worcester Plantation. And an interesting quote from, it was voted down. Interesting quote from William Wallace, the executive director of the Worcester Historical Museum. I think we need to know our history better. We jump, if someone says they're offended or bothered by something, that gives them a right to dictate policy. To me, the Old Burial Ground is a historical cemetery, and these flags are historical representations of the era of those people interred there. Now, I am a veteran, but I'm not here speaking as a vet. I'm speaking more as a failed history major from my first year of college. I learned some. Don't tell my mom. But no, this is important. We don't discuss what the Gadsden flag is. We say, oh, we saw it at a place I didn't like, let's get rid of it. I have a friend here in town who had one of the police supporting American flags with the blue stripes. And a local kid tried to steal it and take it down because they didn't like it. we're saying, all right, you can do what you want if it bothers you, if whatever it is you're acting on bothers you. And I think that's the wrong message. We had the comment made that people are using, I guess Mr. Wynot is using his position to advance his opinion, his thoughts. But I think we could say the same about what the Historical Commission is doing. They've used that pulpit to paint the Gadsden flag. And you can probably guess which way I'm leaning, but I would strongly recommend, voting against this article. The flags are important, they're historical. If we need anything, we need to discuss what they mean. The kids should know what the flags mean and not be told what someone else thinks they mean. Thank you.
Thank you. Let's come back to this side, please.
Bob Flynn, 48 Wildwood Drive. On January 6th at the insurrection, the Proud Boys and the Oath Keepers led mostly with American flags. We're not letting them take that from us. And some idiots brought the Gadsden flag too, the flag that was one of the early flags of the Navy, acknowledged to be the first flag of the United States Marine Corps. I don't let them take that from us either. I think these are historic. I think they represent the Revolutionary era. They should stay up. And just because a couple of idiots on January 6th carried it doing illegal things doesn't change its meaning to the most of us. And I think we should oppose Article 12.
Thank you. Over here.
Rebecca Deansrow, 17 Harris Drive. I just want to start by saying that I think framing this as an issue of whether we respect or honor the veterans is misframing it, because I think the vast majority of people respect and honor veterans, and we support the individual graves being marked. We support the wonderful All Wars Memorial. But there is a place for that, and there's also a place for people who are not veterans, the vast majority of which are in the old burial ground, to also rest peacefully without symbols that might mean something different to different people. And symbols are not locked in time, they change. Just because something was acceptable 30 years ago doesn't mean it's acceptable today. And even if you believe it's acceptable, if it offends a significant number of people, because it's really not a small group. If you do some research online, you will see many communities are addressing this issue. The Gadsden flag goes back to Gadsden's Wharf in Charleston, which was a major place for slave trading. That is why many people object to that, and it is also probably why many groups, including the KKK, adopted it in the 60s. It is a different message of don't tread on me. It's a warning to different people. It's no longer a warning to the British government. But even if you don't believe that, a historical cemetery on the National Register with, there are actually guidelines. The DCR recommends no flags in cemeteries, and if you look around at other historical cemeteries, you will find no flags. So it isn't about respecting veterans, it isn't even about history, and those of us who've been working to preserve Southborough's history for many years, myself 8 years on the Historical Commission, and I can't even remember how many on the Society, we worked very hard to preserve the history. And that's exactly what we're trying to do right now. Thank you.
Okay, thank you. Welcome back.
Yeah. Yes. Do I have to say my name again?
Yes.
Okay, Alex Deansrow, 17 Harris Drive. You can, well, imagine that I'm making an idiot of myself. Imagine a son supporting their mother's opinion. Imagine that. Isn't that strange? I feel it's important to note that I am honestly of the opinion that it is, in fact, a small group of people who are left with the impression these days that these flags are in fact historical and have not been co-opted and their meaning essentially changed in daily life. I'd urge everyone in this room to think back and try to imagine the sort of people who you interact with on a daily basis who fly the kind of flag like the Gadsden flag. And I want you to be honest with yourself. Thanks. Thanks.
Okay, thank you. Over here.
Hello, I'm Pamela Seda. I reside at 2 Brookside Road. I'm in support of Article 12. I think it's really important that the town adopt a flag policy. I am concerned about the modern messaging of a number of the flags that are flying in the old burial ground. Symbols do change meaning in time, and it's very important that our town government is sending an inclusive and welcoming message to our diverse residents. Additionally, I think sometimes it's getting lost in the discussion that this is a civilian burial ground. I know it's been mentioned a couple of times, but this was a burial ground of women, of children, of non-veteran men. It does include veterans, but it's not a veterans burial ground, and we do have Veterans Memorial just a block away where we can acknowledge their service and involvement in previous wars. But as a civilian burial ground, all people in there deserve the sanctity of not having it be misrepresented as something, the burial ground not being misrepresented as something that it is not. And additionally, it's been said multiple times that little flags could be placed next to gravestones acknowledging historic veterans. So I don't see where it's a question of whether or not you're supporting veterans. I don't think anybody is saying don't put little flags next to veterans' gravestones. But let's not misrepresent the nature of what that historic graveyard is. That I lost my last thought, so I'll leave it at that, but thank you.
All right, thank you. Back over here.
Patricia Fiore, 10 Winter Street. I think we're getting a little way from topic. I support Deb DeMaria and the essence of her article, which is that the town needs to set a policy so that moving forward, we don't have these kind of discussions. There's a policy. I also agree with her that this is a public cemetery, a historic public cemetery, where not all people buried there are veterans. In fact, as she pointed out of 1,000 graves, we can only trace that approximately 50 people were veterans of any wars. So is it appropriate to fly veterans' military flags on the other grave sites? Many of which, or some of which, are absolutely underneath, directly underneath those flags that are being flown. There's no grave markers there, but that's because they were knocked down in a hurricane. The graves are still there, directly below these flags, and I dare say they could be children, they could be women. They aren't veterans. In regard to the issue that was pointed out, whether or not it is a private person making the decisions to fly these flags, I've looked at the website, and let me just preface this all by saying I wholeheartedly agree with what Rebecca said. We are not disrespecting our veterans at all. We certainly appreciate the service of each and every veteran. And we have plenty of places to show due respect in our daily deeds and in visiting places like the War Memorial and the All Worlds Memorial and the Veterans Memorial that we have here in Southborough. But we were told that the veteran's grave officer is the person that makes these decisions, and because he is a town appointee, that gives him, he's no longer a private person. I just want to read for 1 second from the town website and the Veterans Grave Officer, and I believe this was written by Mr. Wynot. It says, as Veteran Grave Officer for the town of Southborough, I consider it my duty to see that all veterans whose final resting place at the Rural Cemetery, Burnett Cemetery, or the old burial grounds are respectfully honored. It is my goal to ensure that each veteran's grave is appropriately marked with either a grave marker, a flag holder, or an American flag. So I think the responsibility of the Veterans Grave Officer is to provide that which he does at Rural Cemetery, where the Boy Scouts help to put up all the flags, as my son did, or the veterans' flags, the individual flags that are on the grave markers. And I don't think that this petition is speaking to that at all. We're only speaking to those flags that fly above all of the others, and that whether they're questionable or not, they're not needed in a non-veteran cemetery. So in conclusion, when you all are saying we need to respect the veterans that are buried there, and we need to respect the veterans in this room, we do. But I do ask that you also show respect to the non-veterans who are buried there and the non-veterans in this room who feel that that is not needed in a non-veteran cemetery.
Thank you. Over here.
Colleen Hoppy, 218 Quiddle Road. We keep on hearing about the historic cemetery. That is what it is, a historic cemetery. Veteran or non-veteran. It was a time in our era when that flag was represented and those people lived in that era. And we're taking that away.
Thank you. Back here.
Grant Farrington, 58 Flag Road. I strongly support this article. To me, this article really has nothing to do with the flags that are flying there, but really it's a matter of free speech. By not having a town policy and by allowing a private group, the veterans, to fly their flags there, it's really opened the door for any group to fly their flags there as well. You know, this can lead to all sorts of problems. You can have hate groups that could fly their flags there. Anybody who wanted to, you know, if you're a neo-Nazi, you could fly a swastika there. Anything like that, you can just plant it in the ground. You know, there's no permission necessary because we don't have a town policy, and now there's a swastika in our town center. So, you know, this really seems to me like it's not necessarily about the flags that are there, but it's about reacting to this, you know, pretty major Supreme Court decision, which really opens up speech in ways which may be unsavory, but definitely do have an impact here. So, thank you.
All right, back over here.
Kevin Miller, 18 Ladisquama Road. I am the current chair of the Historical Commission, speaking as a private citizen, however, and it bears a quick mention of why I'm speaking as a private citizen as opposed to on behalf of Historical. When the Board of Selectmen Select Board met on September 25th, we were also meeting the same night. And I happened to notice on the Select Board agenda that afternoon an item that suggested that they were going to take up the matter of asking the Historical Commission for an opinion on the flags in the old burial ground. So our meeting, which was going on simultaneously under other business, I said to the members of the commission, listen, I see on the Select Board's agenda they have this item. They may take a vote. They may ask us for an opinion. Do your homework. Be prepared. Be ready. Go home. Because if they do vote to ask for our opinion, I'm going to call a meeting forthwith, hear your opinions, your independently arrived at opinions, discuss it, see if we can come to a consensus. As always, we take public comment, and then we're going to give a recommendation to the Select Board. That item was raised by Ms. Cook, seconded by Mr. Stivers, and then voted down 3-2, the Select Board declining our input on the matter. So one of the reasons I support this article is so, which again is non-binding, so that the matter is sent back to the select board for them to take input, to analyze the situation, and to come to a policy that will apply to the town and settle this matter. Now, I want to say that, listen, I've only been a member of the Historical Commission since last June of 21. I've only been the chair since March. I don't know the players involved here. I wasn't involved in the previous kerfuffle over this matter. I don't have any history. So when this came to my attention, I tried to look at it with a fresh set of eyes. You know, frankly, my personal inclination is I really like those flags. I think they look really nice. They're attractive. One of the photos that Ms. Demiria used in her presentation was taken by me, as submitted to the master plan committee. I walk in those cemeteries a lot. I enjoy it. I have deep personal feelings for Veterans Affairs. My wife is a career VA employee. I have family history on both sides of the family of veteran service. You know, my father-in-law served on a helicopter gunship in Vietnam, treated for cancer at VA hospitals, compensated for Agent Orange exposure. So I have a very deep feeling for the need to honor, serve, and protect veterans' interests. That said, in my own independent research on this, I find the flags, frankly, problematic, both for historical reasons, for the Shurtleff versus City of Boston decision, and, you know, in trying to research this with an eye toward respect for the veterans, because my natural inclination is to defer to them. So I wanted to find out what honorable treatment in a cemetery for veterans actually is. So I reached out to the PR director at the National Cemetery in Bourne. I don't know if even a lot of people realize that there's not just one national cemetery at Arlington, but there are national cemeteries throughout this nation. In Bourne, Massachusetts, 750 acres adjacent to Otis Air Force Base contain the remains of just about 80,000 American servicemen and women. 80,000 in Bourne, not far from us. So I reached out to the public relations associate, Mr. Robert Belcher, by email. I identified who I was and what I wanted. What I wanted to know was, what flags do you fly at the National Cemetery in Bourne? And specifically, on what occasions, if any, do you fly battle flags? Mr. Belcher brought into the conversation Assistant Director Christopher Hickey and Director Mark Pollan, because I think he wanted to get the answer exactly right. So all three of these gentlemen were on this email string with me, and here's the answer I got. What flags are displayed? The only flags we fly are the US flag and the POW MIA flag. I should note that at the All Wars Memorial, visible from the old burial ground, from the site of the flagpole, that one flagpole that's permanently installed there, you can see that array of flags at the All Wars Memorial, including the POW MIA flag. The VA flag, flag of the Department of Veterans Affairs, is flown only on Memorial Day. As to the matter of battle flags, they are not flown on the cemetery grounds, no matter the occasion. That's a direct quote. So I think to myself, if for the 80,000 men and women that gave their lives for this country and that rest in Bourne, if that's honorable treatment, why are we having this debate? It seems to me we have one permanently installed flagpole. There's one flag of this country. It doesn't matter if you're conservative, liberal, libertarian, progressive, whatever your persuasion, Coke or Pepsi. It's one flag, it's one country, we have one flagpole, let's fly it. But again, this article is sending a message back to the select board to take up the cudgels make the hard decision, and I welcome the input and the conversation with the representatives of the VSOs in this town, because I take very, very seriously and very, very personally honoring them in the right way. And I think the right way is to clear the clutter, unite the town under one flag, and honor the veterans of this town and all the civilians with simplicity and dignity. Thank you, Mr. Moderator.
Bonnie Faniff, 179 Middle Road. I usually do things in the shadows, so not to bring attention to myself unless I'm sitting elected at a board table. I'm the individual in town that takes care of the gardens in the town common at my expense, my family's expense. I take care of the cannon. The family put the flag in the town common at their expense. I spend more time in the evenings in our town common, in the rural cemetery, at the old burial ground, picking up broken flags, disposing of them properly at the town transfer station, a box that was made for the veterans. I have never, in the 22 years that I have been doing this, with the exception of, I do not mow the grass. I take care of everything else. I have never heard a complaint from a single resident in this town, even from those that have stopped to thank me, not asking who I was, not sharing who I was. Those that have asked where I get the flowers. That's, if they're talking about the monument down in the town, the memorial, Veterans Memorial, a lot of those plants I've gathered from homes of veterans in this town, from their widows, from the widowers, or houses that have been destroyed. I asked of the veterans agent, Mr. Wilson in the past, who I only share that information with, if they were to be removed, please put them someplace safe. But no one has ever complained to me about any flag located on any property in this town. And I spent at least 2 nights every single week picking up broken flags, disregarded flags, torn flags. Over the last 2 weeks, have I been in the old cemetery? No, due to a health issue. And I'm sure some of them need to be picked up. So if anybody gets up to the mic to criticize and say they haven't been, you're absolutely right. They have not been in the last 2 weeks. This issue needs to be put back under the Board of Selectmen. They have control and custody of the property of this town. This article is too vague. I suggest that you vote it down.
Okay, thank you. Over here.
Yeah, Jim Caleri, 51 Central Street. A couple things that have been said that have kind of rocked me a little bit about this whole issue. When we look at the public cemeteries, the historic one and the one on Corderville Road, people saying the veterans, you know, we honor them, we support you and everything, and they're an equal citizen to us. No, they are not. And I say this way, how many of you in your lifetime have sworn your life to something and put your life on the line knowing you may not survive? I bet you not too many hands can do that here. The veterans can. My family, we brought up to believe they are a citizen a little notch higher than I am. I'm not a veteran. I have put my life on the line for this town and been in peril at times, not as dangerous as you would be in mortal combat, but I always considered them a higher level than I as a citizen because they left their home knowing they may never come back. And it would be someone else making the decision whether they go to die or not. I have 2 brothers who are veterans. Both are at the cemetery right now in 85. Both have the military plaque with them. If I can't trust these people that the Board of Selectmen have appointed to make the decision on the flag, then who can we? Because it'll be a different Board of Selectmen, maybe have a different view. And the other thing, what's going on in society, and I've been in this town longer than most of you people have been alive. and come to town meeting more than most of you people have been alive. We're seeing in the country people who are offended by everything and anything. These flags bother them because it represented something we recognize today. Ask yourself, and I've done this to myself, over a number of the political issues today, what would I have been like in 1860? What would my viewpoint be on race and all these things that seem to cause turmoil? I probably would be a lot different person than I am today. Why? Because we've evolved and I've learned through generation to generation to get where we are today. I think these things divide us more than bring us together. I truly believe that. And I've advocated to some people who are involved in these issues, on more social issues, stop looking at the past. We know what happened there. We know it was wrong. Let's move on. And I think these flags, the veterans have made that decision. The town has been happy with that decision. And now we have some people that aren't, because something happened on January 6th, the biggest disgrace in 100 years in this country, and we think that's in our town? I don't think so. I can't support this article. I think maybe at some point the Board of Selectmen may want to review and have conversation with the veterans, and I would give them more credit to be involved in that conversation than me, because they put their life on the line for these flags. Isn't that right? And the right for us to stand here at town meeting and talk about this issue. I think we need to understand that. Thank you.
Okay, thank you. Over here on this side.
Adam Faniff, 150 Parkerville Road. Just a few things, because I think we've said a lot of things multiple times. I would like to first start by saying it's been said many times in the room that we're not trying to offend the veterans of the community. By saying there's only 50 dead in that cemetery, that's offensive. Because one dead veteran is entirely too many if it happened at a time of war. We're talking about history in this community. Now, I have only been here in town for 44 years, nowhere near as long as Mr. Caleri. But I will say, in those 44 years, we have had Cub Scouts, Boy Scouts, Girl Scouts, marching bands, elected officials, state dignitaries, town citizens show up, support, and celebrate those grounds. I have never seen people up there in protest. And if we're staying in this room now that the flags that are up there are so incredibly offensive and divisive that we can only fly as many little ones as possible, that doesn't make a very good argument. Because if we had everybody up there, or everybody in the new cemetery, their family members wanted to fly the little tiny flags that they approve of, well, if 500 little ones or one big one, if you look at the square foot footprint, what's the difference? I understand people are upset that they may be being placed by single people in town. It's not about that. It's about the history of the community. It's about the flags that are appropriate for the era of the old burial grounds. It's not about a new political narrative being pushed by certain people who are triggered and offended. It's about the history of this community and representing what we currently find important to us, which are those flags in the history of Southborough.
Okay, thank you. Over here on this side.
Joe Provo, 2 High Ridge Road. There may not be anybody with the data here, either the proponents or from historical. And I've only been here 20 years, so not nearly as long as some people. I seem to recall that one of the restoration efforts at the old burial ground, there was discussion about how some of the non-permanent flagpoles are actually through graves. If that is accurate, is accurate, no, then never mind.
I gotta say,
There are, I believe there's 6, holders.
Excuse me, Mr. Moderator, point of order. There are a number, I have not had an opportunity to speak. I don't think the gentleman there has. I think Ms. Demure has spoken twice, so I think it's inappropriate for her to be speaking again. The question was not put to her.
It's fine, Mr. Neal. I'm going to let her answer the question.
Yeah, I mean, seriously, Mr. Semino.
I'll
All right, so look,
There is an answer, Mr.
hold on, Mr. Moran, hold on. Where's the gentleman who was at the room?
Yes.
Repeat your question, please.
If anyone has data that indicates if these non-permanent flag posts are piercing any graves or through any graves, then I don't care what's on top of them. That's disrespectful in and of itself. That's all.
All right, and so do you, look, if there's more than one answer to this, then somebody's not right. Do you think you have the data on that? Or you, Mr. Kalenda?
Yes. The answer is no. So the data.
Hold on, I haven't recognized you yet. All right? I'm going to give, Mr. Weiss, I'll give you 30 seconds too on this, okay? The specific question is, are the flagpoles in question piercing an existing gravesite? And if you think you have the answer, I want to know the basis for that. To anybody who wants to answer. Go ahead.
So the answer is yes. Oh, excuse me, sir. So the answer is yes. We have plotted the location of these poles. Now, when you say pierce, Michael Weiss on 189 Cordoville Road, former chair of the Southborough Historical Commission and president of the Southborough Historical Society. We did do an extensive mapping of the old burial ground by radar in 2008. These grave sites are fairly accurately located. Just because there's no graves markers there, they were knocked down in the hurricane of 1938, but those rows go right across where these flags are currently. Now, I'm not going to say pierce in the sense of these markers only go down 3 feet. But yes, they are in the center of someone's grave. There's no question about that. And no one can say anything different because we actually did the plotting and have the map.
Okay,
Mr. Sabino.
I draw a distinction between they are at the center. I mean, we walk on the graves, right? We walk in a cemetery, unless we're very careful, we're walking over somebody all the time. So I want to be very specific about the question. Mr. Kalenda, and I'll let Mr. Berger.
Mr. Wein, yeah.
Mr. Weiner.
Yes, 31 at 208 Cordoville Road.
Please be specific.
Specific. Russ Horn, who recently passed away, was deeply involved in the old cemetery. And back when this whole fiasco started last March, he sent me a note and he said, the flags are not piercing the graves. The graves are no longer in the radar that they did. Only show disturbances in the ground. So no one can say for sure who is buried in that spot or if they are unmarked. And the other thing is, the sleeves that we have in the ground go down about a foot, if not less. Not 2 feet, not 3 feet.
All right. So I would say, in answer to the gentleman's question, we don't have a definitive answer. All right. No, I'll be a million% objective here. Where's Mr. Healy?
No, this gentleman's ahead of me.
Okay. Go ahead, sir.
John Thorburn, 1114 Madison Place. We're losing the perspective here of what this is all about. It's about the old colonial burial grounds. The people in those burial grounds, whether they're civilians or veterans or whatever, are from the era that those flags represented. They're not today's flags, they're not yesterday's flags, they're from the 1700s era. If those people recognize those flags from that era, and that's over their burial grounds, then that's the way it should stay. Whether it be veteran, civilian, or whatever. It's the old colonial burial grounds, 1700s. Forget about today's dialogue. That's what it represents. I move the question.
No, I can't let you do that. I can't. No one's allowed to make a point and then immediately move the question. It's not fair. Go ahead over here.
I'll get to the end first, which is that Mr. Butler was right, and that unfortunately, I think there's been a lot of words that have been used up tonight, but the time has been wasted. And This really should be with the Board of Selectmen, which honestly is where it was a year and a half ago. So second thing, though, the people are going to decide how they vote on this issue, I suspect, on how they feel politically, emotionally, otherwise. Please do not decide it legally, because Ms. Demurier, her son, Mr. Miller, I can't remember, Mr. Weishan, all without law degrees, who offered legal opinions about what this decision says, are completely wrong. And this.
Well, but I would know that's your opinion, Mr. Hume.
Yeah, but it's my opinion. It's Mr.
Everybody's entitled to an opinion, including you. So yours is no more or less.
It's a legal opinion, Mr. Savino. Or do you not think that your legal opinion is worthy, given your law degree?
You know I'm not offering one.
We've got an opinion from Town Council, Mr. Kalenda.
I would acknowledge.
Yeah.
But nobody else's. Go ahead.
Well, other people who, with law degrees, have expressed an opinion. And again, from a legal standpoint, there's no legal requirement that the town adopt what Ms. Demurier is trying to push. Just not there. Now, a year and a half ago, and this answer is, I think, is Mr. Miller here? His question about, I suspect why the vote failed 3-2 in the Board of Selectmen, because the Historical Commission voted unanimously to remove those flags a year and a half ago. So it would be kind of silly to send the issue back to them. They've already voiced their opinion. They want the flags gone. They were one of the movers for what happened a year and a half ago, which was what should happen. There was a hearing before the Board of Selectmen. I was the chair at the time. We invited people on all sides of the issue. They came in, voiced their opinion, much as what happened tonight. They based it on historical arguments, emotional arguments, political arguments, some legal arguments. And the Board of Selectmen, who have responsibility for this, considered the issue, voted 5-0 to maintain the status quo in the burial ground. Now, the reason we're back here tonight is because people didn't like that answer. But the decision should go back to the people who made it one time before, the Board of Selectmen. This is a meaningless article. It's advisory to a board that's already made a decision once, that I trust to make the decision a second time. And unfortunately, and I've been sitting here for a lot of it as well, we've wasted an hour and a half venting.
Thank you. No, there's no question. There's no question. Let me go over here.
Katie Berry, 23 Richards Road. I move the question.
All right, question's been moved and seconded. As a reminder, it's not debatable. It requires a 2/3 vote to cut off debate. If that passes by 2/3, we move to the vote on the article itself. All those in favor of moving the question, please raise your cards. All opposed? All right, I declare a 2/3 majority in favor, so we will move immediately then to a vote on Article 12. This requires a majority vote to pass. All those in favor of Article 12, please raise your cards. All opposed? Okay, the motion fails. Now, housekeeping. We are past time that we would normally adjourn, but we are allowed to stay if the will of the hall is to do it and finish. Otherwise, we're coming back tomorrow night.
Mr. Moderator. Mr. Moderator, point of order.
Whose point of order? Please stand up.
Dorian Jasinski, 33 Presidential Drive. I make a motion we dissolve town meeting tonight.
That's not a point of order.
Oh, sorry. Whatever it's called.
All right? I'm asking if the will of the hall is to continue to do Article 13. All those in favor,
It's
please
going to
raise
be
your
another hour.
cards. All opposed? All right, let's do Article 13. Ms. Demoria.
Hang tight, guys, I'm not gonna quit. Article 13, Ms. Memoria.
Mr. Moderator, after speaking to the select board, and given the hour, I move to indefinitely postpone.
Is there a second? Ms. Memoria, you said you spoke to the select board. What did you say? What did you say? You don't have to share. I think you probably should make it public.
And I thought that, due to the respect of the law, I thought that the rules were that we would not start any article before 11 p.m. And I asked if it, and this is clearly after 11, but I asked if it would be okay if we indefinitely postpone.
Well, it's always okay to indefinitely postpone. I thought there was maybe something more to the conversation. Okay. Okay, all right, fair enough. Just to be clear about the procedure, we're obliged to adjourn. We can't start an article after 11 unless you agree to it. If you agree to it, we can't. So that's what occurred here. And now she's moved to indefinitely postpone. It's received a second. Requires a majority vote. All those in favor, please raise your cards. All opposed? Motion carries. Do I have a motion to dissolve a special town meeting? Any second? All in favor? We're adjourned.